No question of jumping serial. Whatever the serial comes, we'll take it up. And I'll try to adjust the list. Don't worry about it. It'll reach within a week or so. But don't follow the procedure where jumping the list and somebody will have a grievance. Why should you do that?
Serial
I'll take
January or not serial Raswari.
Make sure that it will be adjusted within few days. Don't worry. Please wait. Please wait. 30.
ହେଲା କଣ ସମସ୍ତଙ୍କ କଥା କହୁଛନ୍ତି ହେଲା
after lunch you are not there. Every day after lunch I am searching lawyers to please come and argue. Nobody comes. No, every day Mr. Ragada says nobody is there. Let us see. Today everybody will do. Tomorrow the list will be different and board will be different.
So I want to finish.
Let us. You be ready and come.
And
May I please to mention, my lord?
Date fixed for due to change of assignment.
Today weekly list I am taking up. Let us see tomorrow what happens.
I will.
Don't mention it. Let us understand what is the board is about. Let us see how I can take up the serially whether or not.
Okay.
May I please to mention, my lord?
Item 162. It was last posted on 4th of July. Today, your lordship had adjourned specifically to be fixed at 2 o'clock. But there's no noting.
Take it up. What is it?
No, we are ready with them.
Oh, you come.
But
If
162.
If it is indicated to 2 o'clock, it is
No,
indicated.
my lords, it was not indicated in the list. That is why I'm mentioning.
Who is appearing for the other side?
No, it's a vigilance case. Criminal
But who is that? Who is the lawyer?
Sanjay Kumar Das is written.
You tell him so that he should come. Otherwise, it will be useless.
I'll inform.
Tell him.
Lordship's a similar prayer, but my matter is out of board. I've given the memo. The matter was fixed on 5th of July for 2 p.m. It could not reach, unfortunately. And then it has not come up. So may it be taken up any day as per your lordship's convenience?
Include matter in the list.
Lordship.
Include. You give it, we will include.
I'll give the number.
Lordship, item number 3 kindly be taken up next week because our learned senior is suffering from fever.
Wait, let us read till 3. Whether your client is still surviving or not, we are searching.
Yeah, that is a
We are
noting.
searching. Wait,
There is a noting also for the
wait.
government.
I'll take it up. Yes.
well let's adjourn bail matter
Bail matter not today. It will come. Don't worry. It will come.
Item number 30 kindly taken at 2 p.m. Item number 30.
30, somebody else mentioned. Miss Bose mentioned it.
Please, boss.
We'll take it up.
Obliged.
Be ready and come. Yes.
I don't know. Matter has been dismissed for default mirror. I filed for restoration.
Sorry?
There are MM.
Restoration.
Matter.
Why have you
Matter has been compromised between the party. Offense generation 498. But
Give it. Restoration. 498A.
again.
Settle. You convicted by both the courts. Convicted by both the courts?
No.
Then?
Matter is pending. The court will.
No. What is
For quashing. For it.
For it. Mention it tomorrow. I don't know whether it. Wait. I'm not taking. I thought it is a revision petition convicted and all.
No.
Please give it back. We'll see. We'll see. It will come. It will come.
The restoration ta apna bahar.
Huh?
Restoration apna bahar.
Who has dismissed in default?
Let me see.
Who has dismissed?
That dismissed before the Honorable Chief Justice. Didn't Chief Justice.
Take it, yeah. Matrimonial dispute unnecessary. Why?
I may be pardoned, my lord. I may be pardoned, my lord. Your lordship may kindly refer to last 2 items for hearing.
Last
Last 2 items. Hearing 186, 187.
What do you want?
Both the matters arise out of one TR. So your lordship directed to tag it along with another. But it has been listed separately, my lord. 186, 187. Your lordship may kindly have a glance.
It's all right. I don't think we can reach there today.
No. It should be tagged because no separated TCR is there.
Tag it. Instead of separately listing, tag it. That's what he said. Okay. We'll tag it now. No problem. Yes.
And another matter Mr. Ponda was submitting that will be argued by Mr. Niranjan Marada, not myself.
Okay.
I have been entrusted with 15 and 16 only.
Okay. No problem. Yes. Next.
Lordship, may I be pleased to mention, my lord,
Yes.
one CRLMC 4870 of 2023, which is adjourned to,
CRLMC mentioned tomorrow.
Lordship, this matter is adjourned to today, Lordship, but not yet listed.
Mention it tomorrow. I don't know what kind of
Obliged, Lordship. Obliged.
tomorrow will be there. I don't know. Yes. Yes.
My
Yes,
lord.
Mr. Mishra.
My lords, I understood what flowed from your lordship. I'll mention CRLMC tomorrow.
Very good.
I'm obliged, my lords.
Very good. Yes. Any mentioning? No mentioning. Yes. Okay.
100.
What about this 1, 2, 3?
100 to 100 first.
100 to?
108 first.
Rejection of petition seeking discharge
Yes.
is under challenge. Vigilance case.
There is no one from Vigilance side today. What happened? Mr. Rijvi is also not there. Call Mr. Rijvi because there are many matters where he is supposed to get instruction today. Whereabout and well-being of many cases.
No, in this
Today
case,
is
the petitioner is silent hearted. No, not discharge. Discharge petition rejected.
Rejected. What is the stage of the charge has been?
Charge has been framed, he says. I came before charge was framed. Discharge petition has been rejected, that has been challenged.
That's right.
Madam.
But there was no stage or charge.
No stay, no stay.
So the discharge petition was dismissed. Acha.
No, rejected.
March. Okay.
My lord.
March not. March might not. Any pass it over. Sir. Pass it over because nobody. Does.
My lord.
Yes. 101. Yes. 101.
101, Lordship. Kindly pass up, please.
What is this matter?
CRLM, Lordship. Cancellation of bail.
Cancellation.
Lordship.
You tell me what are the grounds? What are the grounds?
Initially, my lord, offence is available in lecture, my lord. For that, one of the accused arrested and immediately released on bail by the court of GMX. Thereafter, my lord, 2 persons released and extended 41A, my lord. Thereafter, charge sheet submitted, including the offence 326.
No, charge sheet not submitted. Charge sheet submitted for the same offence. But
Oh, okay, that's
cognizance
taken.
taken under section 326.
And
Then
accordingly, someone issued and
Someone
after
issued
they appear before the.
Grant the bail.
I am for the opposite party 224.
what is wrong in it? Don't bring
Lordship.
so hyper-technical grounds in the bail matters, small matters, unnecessary hyper-technical ground, this happened, that happened, read statute, read judgments. Yes. Mr. Chan.
Madam.
In bail matters, why are you bringing so hyper-technical issues and all? Leave it like that.
My humble submission, madam.
And if you want some additional condition and all, you tell me so that I can relegate it to the trial court. Some condition will be.
It's all right, my lord. Because all my effort is for academical purpose. And admittedly also, the magistrate doesn't have a jurisdiction to analyze.
I know, you are, that day you said, I understood it.
My lord, but now what the things is
But
now
look at the
developed
pressure,
rightly,
look
wrongly.
at the pressure on the courts.
No,
Unnecessary take.
No, my lord, with all respect, these are all our efforts, subject to
You're
appreciation.
absolutely correct. I go with you.
My lord.
But in a bail matter, why to get into, you tell me, will you move some application for variation of condition? You must do that.
My humble submission, my lord may say that because of all such things, because no condition was there, stringent condition that will not influence also the entire this trial process. And my lord will also target the trial within 3 months or 4 months. My lord,
Targeting trial would be very unfair
because-
on my part.
No, my lord, in such a case, my lord, in some cases, my lord is while disposing all case, my lord is disposing with this direction that led the trial because
And I don't know how
admittedly-
many witnesses, what is the position? How many witnesses are there?
6 months. My lord will say 6
No,
months.
why, how many witnesses are there?
Witnesses, my lord. Yes, I have the copy.
See, suppose we give an impractical
No,
target.
only
The courts
12.
are also coming
Only
under
12.
unnecessary pressure.
Only 12.
I'll simply say that as expeditiously as possible.
But time trial will better take on that.
If you can move
My lord will say
application.
6 months. My lord will say 6 months
No,
because
no, see, the fixing target is very unfair on the part of the High Court.
no, my
To
humble-
regulate-
on the one hand,
I don't know, 6 months there will be no officer.
No.
What to do?
magistrate of there, they are.
Many a time it
Currently-
happens.
in our Odisha, my lord, the judicial, my lord, only high courts, this problem is there. My lord is having very less number of judges. Out of
they are-
33, my lord is holding only 20. But super magistrate court and ADJ courts are there. They are plentifully available.
Right, you're right. But there are many contingencies. I'll pass a balance out. Yeah. Madam, by way of the present petition, petitioner is seeking
Cancellation of bail.
cancellation of bail granted to the opposite party number 2 by order dated 29/4/2004 by the learned JMFC Nimapada in GR case number 1245 of 2023. 23. Mr. Chand has highlighted a legal issue or to attack the imbue order. I am of the considered view that although I endorse the legal issue raised by Mr. Chand, but I am not inclined to interfere in the present matter, being a matter where the opposite party number 2 has been only granted.
Has already been granted. And there is no allegation of misuse.
I perused the imbue order. I found that there is no condition imposed by the court.
There are
Conditions.
There are no appropriate condition imposed by the court below while granting bail. Therefore, the petitioner is granted liberty to move appropriate application for addition, modification, or variation of any other bail condition, any other bail conditions. Mr. Chand further submits that there are only 12 witnesses cited by the prosecution in the charge sheet. Therefore, he seeks indulgence of this court to for a direction for expeditious disposal of the trial. Expeditious disposal of trial, taking into the consideration regarding head to the facts of the present case. I feel it appropriate to direct the trial court to do well to see that the trial is disposed of as expeditiously as possible. Yes. Next.
In some condition.
Condition you move application, whatever condition he'll see.
My lord has not added the. My lord has only said that condition. It was my prayer, but my lord has not added anything that regarding any direction to the concerned magistrate to take
Yes,
it.
I have said that. If such application is moved, the same shall be considered on its merits.
Excellent. Yes, sir.
Yes. Which one?
100.
100 years.
Item
yes,
one,
sir.
my lord, sir, by now, one person. Take a setting. My lord, I pray for one person.
Pass over in presence, pass over.
I'm sorry, but I was
It's all right.
But then I may be accommodated if I'm not there.
You can attend other work and come.
My lord.
Whenever you come, I'll take
My
it.
lord.
Why to waste your time?
My lord.
Sorry, that's just ask, sir. Yes, sir is also there. Yes. 100? 104?
Yes. Item Section 391 for additional evidence. What has happened, my lord? The conviction is primarily on the ground that she has paid, she was the executive officer for 2 months in that panchayat. And she has paid various amounts to people without proper vouchers. But these, and they have also denied these facts. And my lord, he has Xerox copies of all the vouchers, which are there in the guard file. Unfortunately, for the inadvertence of the trial court lawyer, my lords, my lords, receipts were not brought to the notice of the court nor were called for. Otherwise, it could have been confronted to the IO and the other ones.
Right.
So that is why I'm moving an application under section 391 for additional evidence, my lords, which your lordships, the apex court has held that the intention of 391 is that a prosecuted person should not escape unpunished, nor should an innocent. If your lordships prima facie find that yes, there is latches on the part of the lawyer out there in calling for these documents, then your lordships may call for these documents
You,
or
your application is turned down.
no, my application, she has been convicted.
Your appeal is pending.
Appeal is pending before your lordships and 391 gives your lordships the powers at the appellate stage.
Oh, sir, this is, appeal is pending here.
Yes, sir.
Here the application, okay.
Yes.
Here the application, yes.
391
Okay.
is, my lords, your lordships have the power to call for the
Yes,
records if your lordships feel it is justified. That
Yes.
is why I'm
Who
moving.
is
an
opposing?
No, my lords,
Is-
we are-
Yes, my lord, I am appearing on behalf of Vigilance, my lord. The paperwork is ready. Both the accused, this particular appellant
No,
was
paperwork is ready. Paperwork is ready insofar as the appeal is concerned. But in between,
Yes.
he moved an application, 391 application. Do you have any objection to that?
yes, no copy has been served. Let copy be served. Let copy be served.
My lords, I
No
was
copy has been served so far.
just appeared now.
Hmm.
This matter was with another friend of ours. My
If
lords,
I felt necessary, I will file objection. Otherwise, 394, your lordship's discretion is there. If I feel necessary, then I may file objection. Otherwise,
Like that's what are you having objection to that, or I'll look into the file application and see whether it is necessary. I'll exercise discretion.
my lord, unless I go through the petition on which documents are to be marked as exhibits, how can I say so?
I can give another.
When do you want? I issue notice on the application. Issue notice on that application. Which is that application?
1859 of 24.
1859/24. Issue notice to the respondents. Who shall file a reply within a week, least next week, Monday. And we will not waste time in this case. And you tell me if you have a serious objection, you tell me. Otherwise, we'll allow the application. See, ultimately, you have to reach in the truth. That's all.
My lord, my submission before your lordship is that at
Difficulty
the time
apart.
of hearing trial, this appellant, neither this appellant nor her co-accused adduced any evidence, nor filed any documents, nor exhibited
That's
any
right.
documents. Your lordship may kindly have a glance to the judgment itself. So at
That's it.
this stage, they want to fill up the lacuna by filing certain documents. Unless and until I go through the same, how can I say so, my lord?
Yes,
Your
therefore
lordship
I
may kindly have a glance to the judgment.
okay. Therefore, I issued notice. You file response. I'll put it next week.
Copies may be no, next week, 1 week
The
after.
copy
Your
of-
lordship, he
one
said
minute,
1
the
week
copy,
after.
1 minute, the copy of application as well as the appeal memo shall also.
No. My lord, when appeal memo, copy was served in appeal memo. This appeal has already been admitted since 15/5/23. This appeal
What
has
do you
already.
want, Mr. Das? What do you want?
He wants a
I want this
Copy of application. I have already given direction.
394
Copy of-
application. Copy
You
may be
will
served.
you will get the copy today.
Yes, my lord.
What is your
I will
problem?
file my objection. I pray before your lordship to take it 1 week after. I pray
Exact-
before your lordship 1 week after.
Exactly the same thing I'm saying. Why are you hyper
Oblige,
about it?
oblige.
Please have patience to hear. I have
Yes, madam.
issued notice. You file reply. I have adjourned it for 1 week. Next week, this matter will come up. If you have serious objection, you tell. If you don't have objection, then we'll deal it with accordingly.
I pray before your lordship 1 week after, not next week. I prayed that.
Leave this Friday, next Friday. 9th. Okay.
9.
Yes.
Oblige. Item 102.
107.
Let's first serious.
Reason
Hmm.
where the petitioners have been convicted under 506 to arrive for 2 years and pay a fine of rupees 1,000 and in default to undergo arrive for IU has not been examined.
IO is not examined.
No, and no independent witness has been examined.
Then the evidence of PW2 only.
No, yes,
Informant.
2 and 3. 2 and 3.
How will you doubt 2 and 3?
Minutes. 2 hochi informant, 3 hochi,
And 1 and 2, 1 and 3 are the villagers.
yes.
4 and 5 are the witnesses to the seizure of documents.
And the whole difficulty is there is no confrontation because IO was not examined. And the delay is not that very fatal. Next day it has been released. IO has not been examined. In this case.
IO is not examined doesn't mean that the evidence of PW 2 and 3 will be discarded.
No, the question is for confrontation. They said 200 people only came over the land and only 5 persons or 6 persons have been added as an accused. And I was told petitioner number 1 is an advocate also. Tirupati Gomango.
Tirupati Gomango, Nokulo Soboro,
These are all Adivasi people, I think.
they are tribals.
Adivasi people.
Conviction under only
506. 147, 506.
49.
506.
506 only. 506.
Section number 506.
Evidence of 2 and 3, my lord.
Not 2 and 3.
They have paragraph 3 of the trial court judgment.
And some 2 of the persons, as I see, they were 60 years then. I don't know what will be the age now.
What is the age? 29, 49, 55, 27, 35, in the year 2009.
Petitioner 2 60 years and petitioner 3 66 years.
And some of the other witnesses, they did not support also the prosecution story.
1 year sentence, huh? 2 years.
No, he has had 2 years. 2 years.
Full sentence.
Yes.
Full sentence.
How much you have undergone?
I don't think I have not undergone anything.
Can you just check it up? You check it from the record if you have undergone substantial period.
I
you
don't
convert it to
try
undergone.
put.
See, it may extend to 2 years. Full sentence is due. He will check it and tell me.
Okay.
Accordingly, we will decide.
All
Or
right.
otherwise, do you think I will extend you the probation?
Yes, Professor, you can do. Your Lordship do that. Your Lordship do that.
Undergone period, you tell me. And if you have
Obliged.
undergone little bit, probation.
Obliged.
Undergone period, you would have tell. It is your job now. Yes. And this matter is pending since years and years. There is no point. Yes. Two.
May I please? This is an appeal with one thing I say with your lordship. There is a direction to submit the paperwork by me. That may be withdrawn, my lord. It is otherwise ready. Move paperwork ready kari the order difficult house.
Photocopy kari de debe to.
And already appeal memo is there and evidence copy I have served on the vigilance also.
Yes.
Except that I will not rely on anything else.
Yes, Mr.
And
Rijvi, you have the copy.
ना vigilance. Review thile पर एक पढ़ पढ़े बाहर.
Rijvi appeared.
What happened? The petitioner is in deathbed. Se पढ़िलानी मासेलानी पूरा माने ता गोड़ा हाथ चालूनी. For that reason, his son is telephoning me every day. And apart from that, he is a attendant, and the doctor who has asked for the bribe, he has been acquitted. The attendant has been convicted.
So you have a good case.
For 300 rupees, he has given in his pocket.
Yes, Rijvi.
Having the file with you.
102.
We have to constitute the
doctor who has demanded, he says, I haven't seen it. If he is acquitted, the attendant is convicted.
The problem
and
is
he is telling that file is not with him. I will give a file today also, enter document.
Give the file today and come prepared tomorrow, we'll finish it up. If that is sent, this man is in deathbed.
Paralysis ତା ଗୋଡ଼ ହାତ ଚାଲୁନି।
ଆପଣ ଫଟୋକପି କରି ଦେଇ ଦିଅନ୍ତୁ ଆପଣ
ସାଙ୍ଗେ
ଯାହା
ସାଙ୍ଗେ
paper ଅଛି
ଆଜି ଦେଇ ଦଉଛି ରିଜ୍ୟୁ ଆମକୁ
ଆପଣ
ନେଇ ଦଉଛି।
ଦେଇ ଦିଅନ୍ତୁ so that he
ଆପଣଙ୍କୁ
can
ଦେଇଦେବି।
at least read it tomorrow day after any time.
Yes.
Go do it. You have a good case.
Yes.
One of the accused has been
Acquitted.
acquitted. The chain is broken.
Nice. On Thursday, we can take it up on first month.
Except Friday, any day else.
Thursday, huh?
Yes.
Specific urgent to Thursday and get ready, you will finish it.
Oh, I will serve the copy.
Yes. I need not write, you do it. You exchange yourself. Yes.
May this may be taken up in fresh admission.
Fresh admission. No problem. Yes.
105.
105.
105 kindly pass over for the day.
Passover.
That's it. Pass over for the day. We taken up to
No. What is this matter? 2011.
convicted under section 138 of NI Act.
138.
Let's see.
You are accused.
Let's see.
What is the check amount?
45,000.
45,000.
Let's see.
You come with the check.
Pass over for the day.
I'll pass it over. But I'll not interfere. Two courts have convicted in a 138 matter that to 45,000 rupees. For that, High Court intervention is required. You get the draft. Tomorrow?
Let's see.
Tomorrow. Tomorrow supplementary, he will get the draft. Draft of the check amount. At least give the check amount. Forget about the penalty and all. I'll try to persuade the other side to accept that. Okay? Get the draft tomorrow. Elder counsel for the petitioner submits that this is a matter arising out of a proceeding under section 138 NIA. The disputed check amount is 45,000. 45,000. Elder counsel for the two courts have already convicted the petitioner. The elder counsel for the petitioner submits that he would get the draft of rupees 45,000 by tomorrow. Least the matter tomorrow.
106.
Yeah.
379 RI 2 years and a fine rupees 1,000.
Nobody is there. 2014. Pass over. If anybody comes, it's all right. Otherwise, what we'll do is first time it has come. First time. Non-APS. Then I put up for this. Who is the counsel?
Mr. A. Tripathi.
No.
106, sir. JN Panda. After regular last week, after was the lesson.
Pass over for it.
108.
Please, your lordship has directed to the state council to hear about the 11th petition.
IIC.
My lord.
Hearing here.
I had not obtained, my lord. And taken up tomorrow, my lord. I will take. Sorry.
Let it lie over in the list tomorrow, madam.
Day after tomorrow.
Day after.
Awaiting. Instruction awaited. Instruction awaited day after. Okay. Next. One. Come to one. Yes.
Item 1.
Mr. Rijvi is there? Where has he gone? Mr. Rijvi, he has to. Yes.
Conviction for the offense under section 5(2) read with 5(1) C of the old PC Act.
He's surviving.
Survive.
You got the instruction?
Appeal of 94.
94, but the
I will not take much time.
appellant is
Appellant is there.
Alive, my lord. Item 1 minutes. He is alive.
Alive.
Right.
Okay.
Your lordship may see at flag A.
Alive.
Alive.
I take it. He also says alive. Are you ready?
No, my lords.
Huh?
My lords, actually,
It's
there are
94 matters.
Yes, my lords.
94 matter
Sometimes
ତମେ
you have
ଗଲା
to wait.
ସପ୍ତାହରେ ଆସିଥିଲା.
My lords, actually, item 7, 8, these all were prefixed matters, so I have prepared these things. Item 7, item 8, and another item is there, item 16.
See, I will only request you, the 90s matter at least get ready
My lords.
so that we can finish it up. See, 1994 matter.
My lords.
So let it be there on the board.
Yes.
You get ready.
Yes.
And whenever you get ready, then please tell him that.
I will.
It's a small
he-
case. Tomorrow also he can get ready.
Small for you, sir, but for him maybe. You let him get ready and
I will inform my senior.
intimate
Yes.
his
Yes,
office.
definitely.
Intimate it. Let it be there on the board, sir. I'm not going to adjourn these matters. We will finish it up. Somehow or the other. Yes.
Item 2.
That's item 2, once we are awaiting the instructions.
Awaiting instruction.
Yes.
Non-appeal for the plaintiff, awaiting instruction. What is happening? Who is the relevant officer? Katak.
Secretary find that out.
Is Vigilance SP Katak?
Yes, ma'am.
He has not given any instruction.
No, ma'am.
Last time also.
Last time also we have taken time on this one.
What is the problem?
Item 2 था, item 2 था. Item 2 थी, बता भी देखा ही तो वो करे 2.
See, 26 June the order was passed. It was listed on 15th July.
Yes.
And we are now reaching August. This SP Vigilance Katak, this is the only default or any other default is there?
Another is there, ma'am.
Another.
Yes.
I'll call him for his personal appearance.
Item 5 is there.
Let him appear.
Yes.
In VC.
Yes.
You can't take it like this.
Yes.
Then we can't wait for him, you know. Item 1 and
Item 2, my lords. Item 2 and item 5.
2 and 5.
Yes.
In the present matter, the
2, 5 and 22 also, my lords.
22 also.
Yes.
2, 5 and 22, correct. Although the order was passed on 26/6/2024 for seeking instruction, furnishing instruction to the Vigilance Council regarding the well-being and whereabouts of the appellant, but the instruction has not come on record as yet. The matter was listed earlier on 15/7/2024 and adjourned for today. Mr. Rijvi, appearing for the Vigilance, says he has not yet received the.
In fact, I have sent the order also on 3/7/2024.
It is very unfortunate that the Superintendent of Police Vigilance, Katak, has not extended cooperation and taking instruction and inquiring about the well-being and whereabouts of the appellant. In that view of the matter, the SP Vigilance, Katak, is directed to appear before this court on day after tomorrow, or day after tomorrow, in VC. In VC, he need not come to the court, in
Yes.
VC.
So also in item, he is also in item 75.
75 also.
Yes.
2, 5, 22 and 75.
Yes, ma'am.
Same order. सारे मैटर एक साथ लगाना कल, day after tomorrow, all the matter in one, all the 3.
With करके लगा दीजिए.
हाँ?
सब with करके लगा दीजिए 1 to 2.
हाँ, along with करके लगाओ. नहीं, separate numbering होगा ना?
हाँ.
हाँ. But आस-पास लगाओ so that he will come and will ask.
Top of the board है दीजिए sir.
हाँ.
Top of the board. Item 1 से शुरू कीजिए.
Yes.
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 That's item 4 also we are awaiting instruction. This
What
happens,
about what 3?
3 matters he could not be traced. We have made one inquiry also. Twice inquiry was made.
Yes, madam.
But he was not traced.
And there are 4 substituted person. One was at the year of 58 in the year 94, and others were of 32, 27. Hope they are alive. And even if they are alive, I was seeking time for today. Can it be taken off on Friday?
You will argue it. Let it be there in the board. Huh?
Yeah.
Let it be there. Yes. Yes.
Oh.
Item 4, my lords, here also we are awaiting instruction. He is from Sambalpur. My lords, in fact, from Sambalpur, we have received a lot of instructions. So
nothing is coming.
No, my lords, they have given many instructions in other matters. In few matters, they have left out. Very few. This is of Sambalpur, my lords, division. So I think, my lords, kindly grant one more chance for this.
Sambalpur, huh?
Yes, my lords.
Mr.
1 week
Chief
after.
Responsible for the vigilance says that he is awaiting instruction from
SP Sambalpur.
SP Vigilance Sambalpur.
Yes.
Sambalpur, he seeks one more opportunity. Please the matter next Friday, next Monday. All matters next Monday.
5th, my lords, 5th of August.
Next Monday, na? 5th,
5th of August.
Yes.
Item 6, my lords.
5 is over. 6.
Item 6. 6 also we are awaiting instruction. This is from Bhubaneswar, my lords.
What is happening?
But in fact, I was just checking out the figures, right? Like, pursuant to your lordship's order, we have sent around 86 for want of instructions. So we have already received like around 60, 62. Only 20, 23 are left. The main defaulter is the Cuttack division, which your lordship has rightly directed. Let him appear. As far as the other divisions are concerned, one more chance may be given. 5th of August.
5th of August. Yeah, thereafter I'll not give chance. I'll direct give a direction to the director of vigilance to appear in the court. Not even a VC. I'll tell him to appear in person. Otherwise, see, we are going nowhere. Yes. 7.
Lots of brief has been transferred.
Whether your client is alive or not, that's the question.
My lord, he's alive perhaps. Flag X, your lordship may kindly see.
Alive?
Flag X. Report has come.
The report furnished by the SP Vigilance Sambalpur indicates that the sole appellant is alive. Leaves the matter for hearing. Leaves the matter for hearing in the weekly. Yes.
6 also alive. 8, my lords. 8 also alive.
Same.
8.
Alive.
Alive.
Same autocorrect. 6. 6.
6 to sir 5.
6, 7, 8. All the 3.
6, 7.
They are alive, huh?
Yes, sir.
Let it be listed. Yes. Next.
9.
9, my lords.
9, my lord, pass.
Just
1 minute passed over. Pass over.
9, my lords, they have conducted an inquiry. The appellant was staying on a rented house at that particular time. So they visited that place, but they were not able to trace him, and nobody was able to tell about the whereabouts also.
What about your instruction?
Pass over.
No, pass over. Do you know that your client is still alive or not?
No.
And my lords, he was working under the DFO Bhanjanagar. So we also visited the office of the DFO to ascertain his whereabouts from there. There also they were not able to tell anything about.
What is your instruction? He was 63 in the year 1995. 63 means now
92.
92.
His whereabout is not known. You are not able to tell anything. We can't presume somebody died. How to go about these matters? These matters are pending since 3 decades, 4 decades. What to do? And make a statement that he has died. I will record it and bring it up. They are searching. They are not able to get. Shall I pass it over?
Pass it.
And the briefing counsel, whoever is the briefing counsel who has briefed you, call him, ask whether he survives or not. I'll just pass it over. Let us see. Get instruction, come. Yes, next.
10 minutes. May kindly peruse flag X.
What? Same. Survive.
My lord, they have not served a copy on me. They have directly sent to the Superintendent High Court. So it's there at flag X.
Flag?
X.
He survived.
Yes,
Right,
ma'am.
same. Huh? Survived. Peace.
He survived,
Survived.
and I am appearing in this case.
So you should be ready now.
That-
Now you ready? I'll take it up. Huh?
No document is,
Yes, sir. No document you have to, yes.
no
give-
document today I am appearing.
I'm keeping it. You
Yes.
get ready. You get the pen drive and. take
Yes,
it.
yes, I will take. And 1 week
Sir.
after.
It will be there.
Oh.
1 week, 2 week, whatever.
Oh.
Lord, sir has come in item
Yes.
9.
9. See, he was 60 something. 1 minute.
63 minutes.
He was 63 in 1995. They are not able to trace him.
I have 3-4 letters I have written, but even my lord, I got that he is a resident of Balangir. I have also intimated 2-3 lawyers of Balangir to verify.
In fact, this time we went to his office also where he was working, DFO. They were also not able to tell anything.
How to handle this kind of cases? These cases are adding to the statistics of pending.
Yes.
My lord.
Not able to do anything.
Yes, second time they killed.
Second time.
Third time we went to the office where he was working, DFO Bhanjanagar. There also they were not able to say anything about him.
Last return we have received on 23/7, address cannot be located.
He's not staying there, sir. That is the problem.
No, we had given a letter to Padeshwar Nagar, Balangir town, district Balangir, but the address is different.
Address
Yeah.
Bhanjanagar.
Bhanjanagar.
Yes.
But ascertaining that he is a resident of Balangir, I got it from record. I have also intimated because 2-3
In
local.
Bolangir and Bhanjanagar, there is one address given in Bhanjanagar, another is in Bolangir.
Balangir address actually, but till date I have not received any.
You have to ask your briefing counsel.
Briefing counsel is from Ganjam. So he says, after entrusting you, he is not in contact with me. Last payment was made while filing 2,500. The year 95 handed over to me.
So how to suggest something how to handle this kind of case?
And that too, defense counsel was state defense counsel. PC Panda, Advocate Bhavani Patna. I have also contacted him. He said it was a defense SDC.
The problem is we can't dismiss in default.
Yes.
And we don't know whereabout. Neither the
Whether he's alive or
neither you know. So it will be only pending for years to come.
Judgment was delivered in the year 88. And by that time he was 63 years.
That's right.
Well, so it will be around 35 years.
Solution
Solution.
29 को जो topics कर sentence ऊपर.
Sentence super 29th.
29th
Corporational case, he will not get any benefit if it will be entered in acquittal. 29th को से address करियर अच्छी से जो point.
29th को भी रखो.
Yes.
We'll find out some.
The section शायद 5 provision that your lordship has.
We'll see. We'll
Yes.
see what to do.
Yes.
There are many similar cases now.
Yes.
Least on that particular day we'll see. Find out something.
29th. 29th.
29th.
No, 29th.
Today is 29th.
Today is 29th.
Yes.
August.
August 9th को था.
August
9th. It was
9th August.
9th August.
Just check it up. The two matter were to be mentioned released until now.
Sridhar Ramakrishna Rao.
9th August.
Ramakrishna.
You have to find out some
My lord,
out of box ideas.
My lord,
to get out of
definitely, my lord,
case.
I should be-
With your lordship permission, my lord, may I request Mr. Dhawal, my lord. Mr. Dhawal, as a member of Bar Council of India, my lords, my personal knowledge is that he roam around almost all important high courts and including foreign courts.
Yes.
My lord. we believe and I trust him that he will come out with some solution.
That's what I'm saying. He has
No.
to think of a out of box because otherwise there is no solution.
I have tried being, I have started my search also.
So keep it in similar matters, na, where neither the prosecution knows about whereabout nor the appellant knows. All these matter 9. And he'll give an idea on that basis he will dispose of it.
Yes. In one of the case, valid addressee was found that he was bedridden, that Muduli. Palas Muduli. Yes, Palas Muduli. Otherwise, here and that Murthy, Krishna Rao, both the cases, valid addressee is not found. However, Ballard, the point is with regards to the construction of proviso.
But you tell me the Probation of Offenders Act.
PO Act is not
yet. No, applicable subsequently after the amendment. What was the position earlier? When at the time of conviction?
Prepare an exhaustive note.
Subsequently the regime has changed. They say that no, in PC Act you can't give it. But what I understand is before that regime,
after 2018 amendment,
so the convictions and convictions are way back in 90s. Then can we apply that law in retrospective and give probation of offenders?
If it is a beneficial legislation interpretation of statutes.
If that is the case, then we can very well do that.
Definitely, Ballard, if a law, if there was no specific bar, and whatever that was done, that has been done through judicial pronouncements, Ballard, interpretation of the provisions during that period. 1947 Prevention of Corruption Act.
Yes. And all these cases are 47.
Yes.
All these
90s matter all 47.
So therefore, we can employ that provision for this also.
Now it will be decided whether the latter interpretation
will have an impact on this. Today I am deciding the
Yes.
That part you just tell me so that
I'll see to it.
We can dispose of all these matters.
Yes, madam.
Yes.
Item 11.
Item 11 also we are awaiting instruction. I call it on.
Which area?
Sambalpur matters. Because Sambalpur area.
Awaiting for
Matters 11. Your Lordship are fixing it to 5-8. If your Lordship are giving last chance, so can it be on 12 matters? 12 instead of 5, let it be on 12.
Let it be 12. Awaiting. 12 could be. So 12 could be.
Grateful.
Yes.
Item 12.
12 minutes, he is no more.
No more.
No, he died on 27/12/2009.
He died. We got instruction from where?
Sambalpur.
Sambalpur.
SP Vigilance Sambalpur.
That the sole appellant has died on such and such day.
27/12/9.
27/9. Therefore, the appeal stands appealed. Yes.
13.
13, your Lordship may kindly see flag X.
Flag X, sir.
I think he's alive.
Alive.
Alive. Weekly minutes.
Weekly.
Yes. 14 also minutes is alive. We have received the instruction.
Lordship, in item number 14, Lordship, my power may be reflected. Lordship, my name may be reflected, Lordship. The matter belong to our chamber, Lordship. Lordship, and paper book may be prepared, Lordship.
Yes.
Paper book may be prepared.
No paper book in this court. You take a pen
I'll
drive
put
and
it
get
in
it.
the pen drive, Lordship.
Leave the old habit.
Yes, Lordship.
Only because of this paper book business, these matters are pending.
Okay, Lordship.
And whatever documents you have, you can argue and finish it up. But
Yes,
only for paper book, it is pending from 90s.
Yes, Lordship. I will take it in a pen drive.
Yes, next.
15 minutes may be taken up on 12.
12, huh?
Yes.
12. Which matter next?
15 and 16 both.
Next.
16.
16 also may be taken up on 12.
12. Yes.
17 minutes flag B. Flag B.
B for Bombay?
Yes, ma'am.
16th, my lord, that's very small matter, Mr. HB. Should take only
No,
No, whether
my,
he's,
my lords are asserting whether he's alive or not.
he's alive or not.
Yes, yes.
Amora alive.
The relation of my
Acha,
friend.
he's alive.
Yes.
So 16 drop kar do. Then 16, let us
Fine.
see 16. Huh? 16. What is this matter?
This is my lord.
Sola number.
Conviction under section 5(1)(d) and sentencing him to RI for 1 year. This case will take maximum 10 minutes or 5 minutes to for you.
Are you ready?
Can we just run the list, my lord, because you are asserting the whereabouts, my lord.
Yes.
10 minutes, my lord.
Because I will just will run through the list. If the time is there, you just call sir. Okay?
Yes.
I'll just run through.
Yes, ma'am. Or for breathing space, my friend may take it to a first matter after lunch.
No, lunch, there are couple of matters already listed.
As your lordship, as your, I'm waiting.
I'll just,
Yes,
we'll
ma'am.
just go through and then we'll call.
Yes, ma'am.
Yes. 17?
17, my lords, flag B, I think he's alive.
Alive?
Yes. Lordship, kindly see flag B. Staying alive.
Yes, alive. List it weekly. Alive, huh?
18, my lords, flag C.
18, huh?
18 minutes. Flag C.
By instruction, no.
Instruction received in the lobby. Yes.
18, my lords, my learned friend is saying that he has instructions, he is no more. 18 minutes.
Yes. 18, na?
Yes.
Radhashyam Agarwal.
Radhashyam Agarwal.
Let counsel for the petitioner submits that before he changes his mind, I'll probably counsel for the petitioner submits that the sole appellant is expired on. Do you have a date?
No, ma'am.
Expired on expired. Therefore, the present appeal stands evident.
My lords, in fact, in item 17 also, he is also Radhashyam Agarwal. I think he'll be the same person or different. You just have to see the cost.
Same.
No.
Yes.
Address.
But you are appearing in 17 and 18 both.
No, only in 18.
18, ma'am.
Only he is appearing only in 18. But
the
the,
same Radhashyam
but the
Agarwal.
appellant appears to be the same.
Write down his statement record and dismiss. Awaited. Both. Chhad diyo. 17, 18. We have to believe the 17, 18 same, huh? Awaited.
19, he is alive. 19 is alive. We have received the instruction.
19 alive? Alive?
Yes, ma'am.
What is this matter?
He has been convicted for 250 rupees, Your Lordship.
250, which year?
2000.
2009.
Trap case was in
7 and 32.
Yes, ma'am.
7 and 32.
Yes,
The trap case.
trap case, Your Lordship.
Get ready then. Huh? Get ready.
Ready.
Let it be, huh?
Yes,
You have
let
to
it
get
be.
ready. See.
Weekly, ma'am.
Right.
Get
Today?
ready. Anytime you are ready, you tell me so that you tell him
Your
also
Lordship.
so that he comes.
Yes.
I'm ready, Your Lordship.
Ready, na? Pass it over, then we'll see today only, if possible.
I have not gone through that.
Not ready.
That's not-
He is not ready.
Yes, Your Lordship.
Need
No,
to
we
paper-
will
you have
discuss.
papers?
Yes,
You have papers with
yes,
you?
ma'am. We will discuss and we will fix it.
Yes, Your
You
Lordship.
discuss and
Yes,
fix
ma'am.
Yes,
it and
Your
tell me so that.
Yes,
Yes,
ma'am.
Mention it immediately.
Yes, Your Lordship.
Whenever he's ready, please mention so that I can take it up. Yes. It's very old matter, 2000 matter. Why
Yes,
can't
ma'am.
finish it up? Yes.
20, Your Lordship, is flag K, ma'am.
K.
K.
He's staying
Yes, alive.
alive, huh? Alive, look.
My lord, in this case, I was instructed to appear. Learned senior counsel, Mr. Sibo, not appearing, that your lordships are inquiry about the matter. In the matter will kindly call on 10 days after. I have no paper. I have
It's all right. It will remain in the weekly list. You get ready, and whenever you are ready, we'll take it. Your name will be reflected.
My lord, Miss
Reflect her
Tirupati.
name also. Huh? Yes.
21 flag D.
Yeah, leave lot. 75 years old.
alive. He
Yes,
seems
Lord.
alive.
I have filed my Bhaktatnama, but I have not received the memo of appeal or any documents. So it, Lordship, keep it in the other day.
It will remain in the weekly list.
My lord.
Take the copies, send your junior
My
in a pen drive so that he can take it up.
My lord. Published.
Let it be there in the board.
Yes.
My lord.
This item 22, there are two appellants. Yes, just a minute. There are two appellants. Appellant in CRA 156 of 2000 is alive. So far, CRA 157 of 2000 is concerned, my lord. This is that SP Katak has to give the instruction regarding.
SP Katak, I have summoned him.
Yes,
to
20.
appear.
157.
I have summoned him to appear. Okay.
22. Do you have any instruction?
No instruction right now.
Yes, I have summoned him to.
23 minus may be taken up on 12 minus 12 week.
12. 24.
There is no instruction.
I have 24 may be taken up on 12/8, my lords. As far as 25 is concerned, he's dead.
Dead.
Yes.
Everything, yeah?
Yes.
SP
Sambalpur.
SP Sambalpur died on
23/5/21.
23/5/21. Huh? Everything. Yes. Okay. Next.
26 is alive.
Alive, huh? List. Yes.
9. Okay.
Yes.
27, my lords, the appellant died. Died on 29/12/2022.
29/12. SP
Sambalpur.
Everything.
SP Sambalpur has done a remarkable job.
Remarkable.
28.
I have appealed for the appellant, substituted legal errors to the accused.
Already substituted.
Already substituted.
Okay. In between, sometime you are evaporating somewhere.
No, my lord. Last time I have appeared, but inadvertently the recording has been non-appearance for the appellant.
Now give in writing this time he appears and let it be there. Let it be there. We will hear it.
Since I could not say, might be a mistake, but last time I appeared, I have.
No, you must mention it because thereafter what happens is if nobody appears, I appoint M.A. Kishkuri. Once M.A. Kishkuri is appointed, then the original lawyer comes.
From the date of substitution, I appoint by.
Okay. Next.
29. My lord, next.
It will remain in the board. Get ready. Yes.
But I am ready a minute. Prepared.
Yes. Yes.
29. Perhaps someone appeared, my lord. That is the reason no instructions were sought for, if I'm not wrong.
Who appeared? B.V. Rautra is appointed. Let it be on the board. Yes. 30th.
30.
30 same.
30.
Same. He was the amicus, perhaps.
Yes. Both will appear. Yes.
Yes.
31.
Yes.
At the time of filing of the appeal, the year of 62.
That is in 2004.
2004.
Now? '82.
Maybe instruction.
Now, vigilance, which vigilance, which this area?
Sambalpur, perhaps.
Is it from Sambalpur area? Sure.
31, the law. 31.
Just check it out. Vigilance police. Sambalpur. Yes, Sambalpur. Vigilance, SP Vigilance. Sambalpur is directed to ascertain the well-being and the whereabouts of the sole appellant. The matter on 12th.
My lords, we have already received the instruction in this matter. He is alive, man.
Alive?
Yes.
He is alive. Get ready, madam.
Yes.
Yes.
32.
32 is alive.
Get ready then.
Yes.
Yes.
33.
LCR, everything is there. You take it. I did not. Anytime you And yes,
33 may be taken upon 12/8.
12, huh? 12, 33.
So also 34.
34 also 12.
35.
35.
Flag C, your lordship mechanics. I think he's alive.
Staying.
Yeah.
Alive, huh? Alive.
Right.
Same report, huh? A report from so and so and received. Appellant is alive. Release the matter. So, yes.
36 also alive.
36 we will.
Pass over, 35 pass over for today.
It will remain in the board.
Right.
We are just going through the list. We are ascertaining whether any appellant has died or survived or not. Then
Right.
yes.
Item 36, I have instruction. Here also reached out to me. We are ready, my lords.
36, yes.
36.
Okay.
37 may be taken upon 12/8.
12. 38.
38, no instruction was sought for. Perhaps someone appeared in the last occasion.
38.
Clause list reflects Ajit Kumar Chaudhary.
In 2006, he appears to be 50 years old. 2006.
Yes.
कितना हुआ? Hmm. 65 years. 68. 68.
He must be alive.
Rendu, huh? Least one, yes.
39 matters, he is no more.
No more.
No. Flag X is the report. And he died on 25/4/16.
Whose report?
Sambalpur. Yes,
Sambalpur. Sambalpur report. Died on 7th day, abated.
In the 192 criminal appeal number 192.6, I've already filed a petition.
This is
in 151.
151. Appeal died, huh? And next, this is 192.
I have already filed for implementation of party. The wife has filed a petition.
The application allowed, huh?
Lordship, in 151 also substitution petition has been filed, Lordship. In first item, Lordship. 151.
Filed already.
Yes, sir, Lordship. It's there in the cost title, cost list also. In the second part, it has been mentioned.
Flag D matters. IA number 1298 of 19.
On in both the cases of IA, huh? IA for IA application under 394 is allowed, huh? Both the application. Then you write amended memo of parties to be filed within a week. Least the matter in the weekly commencing communication. In both the cases, amended memo of parties we filed. 39 is over. Yes.
40, your lordship must see flag X.
Both are early.
Early.
Yes, madam. That is the sub-item is 168 of 2006. My Lawrence Senior, Mr. Das is appearing in that case, and first case is that is CRL 161 of 2006.
Alive, huh? Okay. Yes. Next.
41. 41 alive.
In both the matters, Pramod Kumar Mahanti and Bhaskar Kar. Huh? And whatever Bhaskar Kar.
Bhaskar is alive.
Alive. Okay. Let it be. Yes.
42 matters may take up on 12/8.
12, huh? Yes.
43.
43 matters, someone appeared last time perhaps.
Minutes have appeared on behalf of the petition matter. Minutes kindly 2 weeks time may be granted so we can ready.
Let it be there in the board. Get ready. Yes. Next.
Give 2 minutes.
44 also same alerts.
What?
No instruction was sought for. Perhaps someone must have appeared. My case has been appointed.
Huh?
Mr. Chinchani
Let it
is
be
there.
there, huh? Let it be there. Yes.
45.
45, someone appeared in the last occasion, they have adjourned the matter.
The board is functioning? Yes, 45. Okay, let it be there on the board. Yes, next.
46 amicus is there, my lord, Mr. Chinchan.
Chinchan, yes. Next.
47, your lordship may take it upon 12/8.
12. 48.
47, 48 both, my lords.
48, 47. 12.
So also 49, my lords.
49, 12.
50, my lords, he is no more.
Awaited.
Abated.
Give the date.
Died on 23/12/10.
23, 10.
SP Berhampur.
SP?
Berhampur.
Berhampur. Awaited, huh? Yes. Next.
51.
47, my lords, my learned friend is appearing. He says that the appellant is no more.
47.
47 in item 47. my lord.
Right on. 47 will look. Then consider the date.
It
Do
is
you have the
prepared.
date of
Sir, ma'am.
date of death?
Date.
When?
Date अच्छी
हाँ
Do you
30/7/2022
Eko?
30/7/2022
30 died. Awaited. Let counsel for the petition submission. Yes. Take it.
51.
I have no instruction, my lord.
51, my lords, take upon 12/8, my lords.
12. See.
52, he is very much alive. Alive, my lords. It is ready for hearing, my lords.
Ready for hearing?
Yes.
Earlier, as you said rightly, possible. We'll see if it is possible.
Now the 77 years. That is.
See, I have been waiting to somebody to come and argue. You didn't come. That time you should have argued. Yes. Okay, we'll see. If time permits, we'll do it. Yes, next.
53. 53 also same. Mr. Mond is up.
Nobody?
Madam, 53.
Any instruction? He's alive? Yes.
54.
Lordship, on behalf of Malvinder Singh SK Das praying for a Passover.
Passover. He's alive?
There's no instruction was sought for. So I think they appeared last time.
He's appearing.
Yes.
Okay. Let it be. Yes.
55. Last time, this honorable court has directed the appellant to obtain the instruction.
You are supposed to get the instruction. Well-being and whereabouts. Have you tried or not? What letter nowadays? What letter? Who is reading your letter?
Yes.
A telephone. That letter will
It is
never.
2007 matter also. At that time must 2007.
Let us see the age. Age 60 year in the year 2006. 52 years. Who is that friend? 60 years in 2007. Wrote 70 something, 75 years, 75.
77 years.
Sambalpur. Is it Sambalpur? Sambalpur, SP Sambalpur.
Unless we need to take instructions.
SP Sambalpur is directed to 12. Yes.
12/8 minutes.
12.
56.
57.
57. Last time someone appeared from Mr. Mahapatra's office.
Appeared. No, nobody appeared. None appears for the appellant. On 18/7/2024, nobody appeared. Yes.
What should my point of Micah's?
2007, he was 60 years. Fifty.
67 months.
57, na?
67.
No, 57.
Huh.
Charge sheet, let us see, charge sheet. One 1946 date of birth.
1946. 78 years.
Now he's 78.
Yes.
You have to get aware about. Which
Item
area it
57.
is? This is Bhubaneswar. SP Bhubaneswar. You're about.
Item 57 hours.
Yes, 57. 12th, huh? Wait, yes, next.
58.
Somebody appeared here.
Yes.
Okay. Yes. 59.
59 also last time
Appeared.
everyone appeared on in all the three appeals.
Yes. 59. Ready. 60.
60.
Ready. 61.
61.
Just see 61. '61. 2007, he was 55. Charge sheet, let us see.
Huh? 82 years.
Huh?
82 years as on date.
Then you have to seek instruction.
And that's there are two appellants for that.
Two appellants.
Yes.
No, there is only one. They see Vaishnava Charan's fine.
And Jharna Goswami with
Two items.
Yes, two items.
And what about the other?
Jharna Ghosh.
Jharna Ghosh. What was her age that time? Oh, she was also 67 in the year 2000. Get
81
from Koraput, Barampur.
Yeah.
Which area they belong to? Vigilance Judge Jaipur.
Koraput division.
Koraput division director. Huh? To seek well-being and whereabouts. Huh?
Both the cases.
12th, huh? Both the cases.
Both the cases.
12th, yes.
62.
62, he is no more, rights.
Hmm?
He is no more.
Date, give me.
Date is, my lords, 28/8/17.
28.
SP Berhampur.
Barampur?
Yes.
Yes. I bet it. Yes.
63.
Somebody appear here.
Yes, my lords.
Appraise Bhoi. Yes. Next.
64, my lords, may be taken upon 12A.
12.
65.
65.
65, so someone appeared, my lords.
49 in the year 2007, I don't know, it may be 92. Let us see. This is Tumulu Kedar. Tumulu Kedar. What is his date? Tumulu Kedar. Must be in his 90s, it seems.
So we'll ascertain.
Ascertain it. From this is Jaipur, Vigilance. Koraput. Huh? Koraput. SP Koraput. 65, huh? 66.
66, my lords, he is no more.
No more. Date?
Died on 1/10/16, SP Bhubaneswar.
SP Bhubaneswar.
Okay. 16.
1/10/16. SP Bhubaneswar, abated. Here. Next.
67.
Alive. Right.
68.
Yes. $68. In 2003, he was 55.
$76.
76, yeah.
My lords, on our item 67. 68.
When?
When?
7th February 1953, date of birth. Seventy?
71.
To get whereabout. It is also from Barampur. Barampur, huh? Barampur, SP Barampur. Yes.
69.
Alive, Lordship.
Alive?
Alive.
Okay. Let it be.
70.
Okay. 394 application allowed. Yes, next. 71. At the request of land council for the appellant. Then
Alive, must be alive.
72.
72.
72, I am for the first appeal, my lord. 62.
72, everyone is alive, my lord. It is ready for you.
We will hear it.
We will hear it.
They are instruction time.
Conviction under?
PC Act, my lord. I could not receive any information. My lord. I have tried to contact my lord, whether he is alive or not.
He says all are alive.
Yes, my
Which-
lord.
which
Then
act?
it's okay. First item. 72, first item.
72.
First column.
Gananath Das.
Gananath Das. I am
He-
for Gananath.
Gaurav Chandra Paricha.
Gaurachandra Paricha, he is alive, my lords.
Gananath, you don't know.
Don't know, my lord.
Yes, my lord.
Let us see
I have also
Gananath,
tried to
what-
contact my lord, but could not.
Let us see what was his age.
Now the age is 86.
86, he says.
86.
Then Gananath, you have to seek instruction.
Yes,
Yes, ma'am.
Which is that Jaipur.
It is 62.
Koraput.
62 of 2009, yes.
Koraput. Huh?
And it's only in 62 of 2009.
Only in
Yes.
62.
First one, Gananath.
Yes, ma'am.
And the other one, alive.
She says he's alive.
12.
Obliged.
73.
73.
Taken around 12.
12. Yes.
74.
74, my lords, he is no more. He died on 22/1/19, SP Bhubaneswar.
SP Bhubaneswar. Abated.
76.
75, what happened?
Acha, 75 contact, yes.
76. Obstruction allowed. Okay. Both the matters. 76, there are two matters. What about
Madan and
Madan Mahapatra? What about Madan Mahapatra? Just see this a bit. Madan Mahapatra. In the year 2009, it seems, 65. Madan Mahapatra. Let's see. Madan Mahapatra.
80 years. Let us take the instructions regarding whereabouts.
Madan Mahapatra instruction.
12
Here?
8.
Huh?
12 8.
Where? This is Varam Bhubaneswar. Bhubaneswar. Okay. Madan Mahapatra. Okay. That is 103. Criminal appeal 103. Next.
77.
77, someone appeared last time.
Then
78.
he was 57 in the year 2009, it seems. Narayan.
72 years. 72 years as on date.
Let us see the final form. Final form, the right age you get. Narayan Mahali, na?
Yes.
1950. Year of birth.
74 years.
74. Where about now? Area? Which area is this? Cuttack. Cuttack, 12th, huh?
79.
Let them try once, then we can see. You please try once. Appellant to take instruction.
Then counsel for the appellant. Seeks one more opportunity to get the instruction regarding the well-being and whereabout of the appellant to release the matter on 12th. 12th, huh? Yes.
80.
80 minus may be taken off 12.
This is 79. I passed the order, na?
Well, I'm talking about 80.
No, 1 minute. 79 also.
79 minutes direct.
Baleswar.
Well,
Special Judge Vigilance Baleswar. I have given the direction to them, but she will write a letter. It's neither here nor.
So you have to take.
Baleswar means?
Baleswar.
Baleswar.
Yes.
Baleswar division. HP Baleswar is also directed to.
79 minutes.
79.
12 8 minutes.
12.
80 also 12 8 minutes.
12, yes.
81 minutes, he is no more. He died on 3/2/2024. SP Bhubaneswar.
SP Bhubaneswar. Huh?
Abate.
Yes.
82.
82.
Appellant to take instruction.
What was his age? Just see. Very old. 58 in 2009. What is his name? Virendra Kumar Das, huh? Virendra Kumar Das.
73.
Let us see the
Charge
sheet. I'm looking at the charge sheet. Virendra Kumar. Date of birth 1951. 6/1/1951.
73.
Get whereabouts, huh?
Whereabouts?
She will also take instruction. The same order. This is Baleshwar. SP Baleshwar. Yes.
83.
83, my lord, alive, my lord. Alive, 83. 83.
What happened?
Appellant alive, my lord.
Alive. He's saying alive.
Oh, alive. Okay.
My lord.
Alive.
84.
84 may be taken about 12 8 minutes.
So,
You are also 84. I have instruction to appear. I have already filed the Vaklan.
10 minutes he is alive.
He is alive.
He is alive.
Alive.
Lordship fixed a date for me.
File the Vakalatnama.
Already filed. Name is there.
Yes.
Upasana, Sobasana, and other.
Let it be there. It will remain in the list.
Okay.
I am just running through the list. Let us see.
Oblige.
5.
Alive, huh? Yes.
86 is also ready for hearing. Mr. Jugal Kishore Panda was appearing with us. It is ready for hearing.
87.
87.
Display काम कर रहे हैं ना?
87 minutes में direct the registry to serve a paper book. It's ready in this matter.
Ready.
I beg your pardon. In 87, I have instructions to appear. Lords, therefore, I pray, my lords, let it come on 12/8. I'll file the Vakalarnama and paper books be supplied.
12/8 for this. Mr. Pandal and counsel for the appellant submits that he has got the instruction to appear for. Then counsel, then counsel submits that he has got instruction to appear for the appellant. He seeks to file Vakalarama on 12th. Yes.
I'm grateful, my lords.
88.
Actually, 88 kindly taken on next week.
Huh?
Next
So
week.
ready for hearing.
Yes, ready for it.
89 we have received. The report is at flag X. He's alive.
Milots, I'm for the petitioner, Milots. I'm through VC, I may be pardon. Milots, item 89, the petitioner is alive, Milots. What has transpired is that, Milots, we need some time to for preparation, Milots. My learned senior will be appearing in this matter, Milots.
Let it be there in the board, we'll see.
Milots, can I request it for 28th, Milots? For a particular specific
No
date.
date, it will remain in the board.
It's there on the board.
Get ready and come and argue. Yes.
90.
Milords may post it to some other date because preparation is
It's
required,
already there
Milords.
in the board. Let it be there in the board. Don't worry.
90, your lordship may direct the registry to give a paper book. It's ready in this matter. It is there.
Copy is not given to you.
No, it's been prepared. Noting shows that it with copy of paper.
Copy is not given.
Your lordship, item number 90, your lordship.
Yes.
Kindly it might be passed over, your lordship.
Please give a set of paper.
Right, there is, you have not got the copy.
No, he is appearing, so he can give me a copy of it.
Get a photocopy and come.
Your lordship.
Go. I am passing it over. Get a photocopy and come.
Your lordship.
I am passing it over. Go get whatever paper you have. Get photocopy, one bunch, and come here.
Oh, please.
He is holding the paper book itself.
Let him get the photocopy.
Yes.
Otherwise, it will never.
Yes, I understand.
91.
I am passing it over. Get a photocopy. Like that.
Live and ready for you.
Yes.
92 is a revision, Mr. Dar.
Yes.
92, there's some, I searched from my lord's brief.
Yes.
My name
Lordship
has
forbids my
been incorporated, though I have not appeared in the case at all.
In fact, this is that case, my lordship, in number of occasions found nobody appeared in that case. Then lordship shadowed the responsibility on me to contact my senior Mr. Rath.
Yes.
So I had the occasion to interact with him.
He informed me last night. I was surprised because I have never conducted any criminal case in my life.
No, in fact, the doubt gathered momentum because the accused was a teacher, my lord. My learned senior, my lords, is espousing the cause of teachers throughout in his career, but never appeared in the trial court.
But your name somehow reflected somewhere.
J. Rath, but he is Mr.
I verified from the my lord's brief. No Bhaklatnama, no appearance, nothing has been there. Probably my learned friend said there is a J. Ratha. He thought that J. Ratha senior advocate, that is mentioned in the last order of my lord.
And coupled
that should be corrected.
And coupled with the fact that accused was a teacher. You were
I understood what have misled you. I understood. My lord, that may be corrected because
Why can't we have the privilege of hearing you as a case?
my lord, my problem is I have never taken a trial or a criminal matter. I have also, but
very fair submission.
Okay, then sir is there behind you. You pass on the baton to him. He will argue. He can't say that I don't know criminal law.
And if my lordship permits, my lord, I had the rare opportunity. I had cross-show with Mr. Senior Advocate Mr. Rath. Before Justice R.K. Patra, I was in charge of bail matters. And when Justice Patra saw, Mr. Rath, eti vi apono? But in a bail court.
Sir, se gote bail gote thila. He was really surprised. Taken in shock. How it is that you have come in a bail matter?
Accused was a teacher.
Because any teacher, even if they are accused,
he
Don't say any matter, my lord, Mr.
he found that the teacher and there is a jail authority. He thought that it must be me, sir. So that last order may be corrected.
Yes, I'll correct it, and now sir will appear as a case.
You will appear, sir.
But I'll tell you, your junior, that girl has.
And Miss Mishra, very articulate.
Very articulate. The other day she argued. You have given right training to her.
Yes.
Really fantastic. She has really argued. Appoint her as MIK in this case. He will supply the copy and she will argue. See is
obliged, man.
Yes. Thank you for.
Her name may be reflected.
Name of Mr. J. Ratho, Senior Counsel, will be deleted. William is appointed the magistrate to assist me, and he is directed to supply the entire paperwork to MS Mishra. Let it be in the list. Supply the copy. Yes.
My lords, may I just request my lords to come back to item 68?
68?
Yes, my lords.
Yes.
I am for
He is appearing there for 68. Lordship has passed order to ascertain the whereabouts. He says he is alive, so it's ready for hearing.
I have mentioned. I am ready to argue the matter last to the occasion.
Yes.
So let us sort the make.
No, it's there in the board. I am just running through the board. Let us see if some appellants have already died, then we will evade that. Then the board will start. Yes, next
12 age.
93. Alive. Okay. Yes.
94.
94. 94. years, 50 in 1999. Kamalakanto Das. That's Kamalakanto.
75 years.
The problem is if you see the charge sheet, the age is something else and the order sheet is something else.
Yes.
Charge sheet is not there. Okay. 50 year in the year 1999.
Yes, ma'am. 75 years.
Where about?
Yes.
Special Bhubaneswar, special judge SP Vigilance. Okay. Yes.
But in all these matters where the noting is not there regarding to ascertain the whereabouts, perhaps someone keeps on appearing on in these matters. So that is the reason this court has not directed to ascertain. But still, I will take the whereabouts.
Still you.
Yes, ma'am.
95.
This matter is also ready for hearing. This is the caption there in the noting errors.
Somebody appeared.
Yes.
Mr. Lenka appeared. Yes. 96.
96 also substitution petition has been filed and it's ready for hearing.
97. 97.
97.
And it's maybe taken up on 12/8.
12. Yes. 98.
98.
98 also it is ready for hearing. And it's
99.
99 also ready for hearing. We are done with the list as far as this instruction part is concerned.
B. Rajiv Lotan Parsa.
And there was one connected criminal revision which your lordship disposed of last week, where Mr. Senior Counsel Mr. Nayak was appearing. That criminal revision matter.
Yes, this name. Oh,
yes. So that is the reason your lordship are recapitulating
that is
this.
section 177.
Yes.
I know, convicted under section
Yes,
177.
yes.
They do that matter.
Yes.
Yes. There was no material. He is the main accused.
Main accused, Rajiv Lochan Parsa.
Okay. Main accused.
As far as instruction part is concerned, ma'am, the list is over for this.
I'll take it up.
Yes.
Then you are ready, sir. Which item?
16.
16.
16.
I'll just come within 2 minutes.
68.
Let us see one after another. I'll take it. Your matter, I'll definitely take this week.
And also 161, since it was enforced then.
In this matter, paper book is ready. Your lordship can have it. The paper.
Paper book is ready. Yes. Yes.
And sentenced to undergo RI for 1 year on both for 5.D and
161 is also.
161 also.
Yeah.
With a fine of ₹500.
The prosecution case is this petitioner was an accountant in the office of the executive engineer, electrical, in the Raniat division. The PW2, my lord, who had a tailoring shop in Vajrakabati Road at Cuttack, he wanted to take line to his premises, filed that applications. After complying the formalities, my lord, supply was given to him. And after some days, since his business didn't click, he wanted to surrender once again. Surrender the line, my lord. But as per the rules, my lord, there is a deduction of ₹50 from the deposit. He has deposited 500 rupees only, and the deduction amount is 50 rupees. And this 450 rupees he has to get back. He had to get back from the office as per the norms then prevailing. So we filed an applications and contacted the authorities there, and the accountant said, it is the prosecution case. It is said that the accountant demanded rupees 50 to refund the 428 rupees. 78.
After deducting 50 rupees, the remaining amount will be refunded.
Yes, 50 rupees. That's after deducting 72 rupees.
70 rupees.
Yes. So the rest amount is 428.
420.
That has to be refunded to him, for which he made a demand of rupees 50 rupees.
Okay.
So it is said that this 50 rupees for which he reported the matter, as usual, a trap was conducted and a trap was laid, and he was caught, and this case charge sheet was filed. He was put to trial and ultimately found guilty for this offense. My respect to submissions, my lord. The prosecution, the trial court, my lord, has placed the onus on the accused and found him guilty. He said that the defense has not been able to prove his innocence, to prove the defense guilty. But the golden principles of criminal law is the prosecution is to prove the prosecution is to prove the case beyond reasonable doubt, and the defense to show a preponderance of probabilities. That is the golden principles of criminal law. The trial court has forgotten and placed the reliance on the defense, saying that the defense has utterly failed to prove the case defense story. Therefore, he is found guilty. PW2 is the star witness, my lord, and who has demanded and accepted the amount. That is it.
PW2.
PW2. Your lordship may kindly see, directly come to PW2 at page 56 of the paper book.
56. Yes.
Doesn't support PW2.
This has been declared hostile.
Your lordship may kindly see the
Yes.
56. I am the decoy in this case. I do not accused. I do not know the accused. After seeing the first line for the further proceeding, your lordship, I am still proceeding. I do not know I had made an applications for giving electric connections to my tailoring shop in GCI Market, Vajrakabati Road, Cuttack, to OSEB Haraniat. I got my electric connections in the year 1985 to 86. On 1 month after the consumptions of the electricity, made an applications to the executive engineer OSEB to refund the security deposit after adjustment of the consumption dues. Exhibit 10 is the application. Exhibit 10/1 is my signature thereon. Order was passed for refund of money to me. The file was sent to the accounts of the office, accountant of the office. I am the accountant. The accused is the accountant. I made to run to him for 2 occasions for getting back the dues. Then he demanded the bribe of rupees 50, to which I expressed my inability to pay at that time. But I promised to pay later on after work is done. But he insisted for payment at that time. As I was harassed, I went to the Vigilance office. I got the report reduced by persons to whom I gave my signatures and submitted to the SP Vigilance. Exhibit 11 is the report. Exhibit 11/1 is the signature. I went to the Vigilance office at 9 a.m. on that day. I was introduced with the officers present, including the magistrate. I might have narrated the allegations regarding demand of a bribe. The preparations was concluded, and I signed thereon. I produced 50 rupees currency note. The phenolphthalein powder was smeared on it. After demonstrations, I accompanied the raiding party. I cannot identify the HOS.
MOs.
Shown to me and
shown to me the names
The
number noted in the currency note, tallied with the number noted in the preparation note. I have given my signatures on the paper. Exhibit 1/2 is my signature, and at the second page, the preparation report. We reached the office. The
Last
accused,
line is very important.
Yes.
But I cannot say if the accused was Shadangi, to
Yes.
whom I gave the money.
That time he was declared hostile and leading questions were put by the prosecution.
Then he put declare hostile.
yes, your lordship may kindly come even by paragraph 3. Paragraph 3, my lord.
It's not effective.
It's not a fact. That is that his earlier my lord statement was confronted. He also denied that to have made such statement before the IO. And the 10th line is, my lord, it is not a fact that I have given the bribe money to the accused. So he denied in the cross-examination also that he has not given the bribe.
Yes.
And my lord, so far this case of this trap is concerned, my lord, the two cruxes has to be proved, my lord, demand and acceptance. So for demand is concerned, my lord, definitely the star witness is the persons from whom the demand is made. This witness, the persons from whom the demand was made. He said there was no demand. And then recovery, my lord, acceptance, my lord. So for acceptance is concerned, he is also the star witness, and the other witnesses also, accompanying witness, they also don't support that he has accepted the amount from this witness, well, from PW2. And so for recovery is concerned, still there is another peculiar story. So for recovery is concerned, my lord, it was not recovered from his possession. It was recovered from the possession of another accused who has been examined as PW.
What are the evidence for demand? Except, see, insofar as acceptance is concerned, if the other witnesses might have supported, no problem. Then honors goes to him. Why has he accepted 50?
Section
That
20
part,
presumption comes.
that presumption comes.
Yes.
But what about the demand? For demand, there can't be a presumption.
Yes.
What is the evidence you have insofar as demand is concerned?
PW 5, page 69, your lordship may come.
Huh?
PW 5, page 69.
For demand?
Yes.
Okay. You have something on demand?
Yes.
Okay, it's all right. So
And
let's
he
take him
happens
continue.
to be the senior clerk.
Because see, the trial court says what sir is saying. Trial court says he could not prove it. Okay. If acceptance is proved through the official witnesses, then the onus goes to his head because section 20
comes into
steps
play.
in. Then he has to prove it.
Yes.
That why he has accepted it.
Defense plea has to be an
That acceptance part is there. But unless you prove demand,
yes,
then entire story
it's there.
collapse.
Something is there.
So
Something
for
is
the,
there. PW 5, your lordship.
but at the same time, the best witness for demand, to answer your lordship's question, the best witness for demand
PW2
is definitely PW2, because demand is made from PW2, my lord. If he says there is no demand, even if there was some corroborating evidence, who stick to their evidence, my lord. If the star witness says that there was no demand from me, somebody A, B, and C, or X, Y, and Z, if they support that yes, there was a demand by the accused.
There should be a direct evidence.
Yes. And if suppose he would have died, that is a different thing. But he's alive, he's a witness, he has been examined, he said there was no demand from me. So question of others saying yes, there was a demand, my lord, will not help the prosecutions. And so for acceptance is concerned also, and it is clear case, my lord, the recovery was made from PW4. Your lordship may kindly see PW4. PW4 accepts that yes, the recovery was made from me, not from this witness. Your lordship may kindly see PW4.
Who is this PW4?
PW4, my lord,
clerk of that office.
He's a cashier of that office, he's the accounts officer.
And he has also been declared hostile.
So these witnesses.
What case you have?
Your lordship may kindly see.
You rely upon wrong people.
Your lordship may kindly see
Yes.
page 63 of the paperwork. I know the accused present in the dock
63
of the paperwork, page
Yes,
63.
I am there.
And he is a witness number, my lord, PW4.
The accused was a junior accountant of the city. And
I know the junior clerk, my lord, attached to OSCB. That accused was the junior accountant, my lord. Then your lordship may kindly see. They gave me the number of and asked me to find out if any currency note bearing that number is available in my counter. The last paragraph 2. While I was in the collection counter number 4, at that time, our executive engineer, Arjuna Sahu, along with some other unknown persons
came to me.
the identity of these unknown persons were disclosed to me as one, the executive magistrate, and the other one is the vigilance officers. They gave me a number and asked me to find out if any currency note bearing that number is available in my counter or not. On verification, I found that the number in a 50 rupees currency note, that's which with the amount collected from the consumers. They wanted to take that currency note from me. They said, ଗୋଟେ particular number ଦେଇକି ସେ ମତେ କହିଲେ ଏଇ ଟଙ୍କାଟା ତମ ପାଖରେ ଅଛି କି? ସେ କହିଲା yes. ସେ ସବୁ ଦେଖିଲା, ଦେଖି ସାରିଲା ପରେ ସେ କହିଲା yes, ମୁଁ କଞ୍ଜ୍ୟୁମର ପାଖରୁ ଯୋଉ ଟଙ୍କା ଆଦାୟ କରି ସେଇଗୁଡ଼ା କେବଳ ମୋ ଆକ୍ସେସ୍ ଅଛି, ମୁଁ ଦେଖୁଛି। ତାକୁ ସେ ଦେଖି ସାରିଲା ପରେ କହିଲା yes, ମୁଁ କଞ୍ଜ୍ୟୁମର ପାଖରୁ ଆଦାୟ କରିଥିବା ପଇସା ଭିତରେ ଗୋଟେ 50 rupees note ଅଛି, which matches to your report. So my lord, the recovery is made from him, and he said that this amount which was in my box is the amount which I have collected from different consumers.
Again, he says, they wanted to take that currency note from me, but I did not agree, as I had to deposit the entire amount collected from the consumer.
Yes.
Lastly, as per the direction of our executive engineers, that the currency note was seized by the vigilance officer.
Yes. So neither demand nor recovery.
Yes, what do you have beyond this?
My lords have put a question regarding demand. May I just clarify that part first?
Yes.
PW5 page 69, your lordship.
PW5 69. Okay.
Yes. He happens to be the senior clerk and he happens to be the overhearing witness also.
PW5.
Page 69, your lordship have it?
Question of corroboration comes when the principal witness, my lord, sticks to the prosecution. My friend knows.
Yes, which part?
Last but 4th line. The gist of his complaint was that.
The gist of the complaint.
The gist of his complaint was that he had to get refund of his security deposit from the electricity board, but the dealing assistant, Sri Sarangi, was demanding illegal gratification of rupees 50 from him to arrange refund of this security deposit.
Who has demanded?
My lords, this accused. This is what he says.
From whom?
And I'm just placing once again the gist of his complaint. Complaint means by complaint made by the decoy man.
The complaint is
made by the decoy man. Thereafter, he has turned hostile. That is a different thing. Right. The gist
but
of
he can't be the witness to the demand. He is reading out the complaint. He doesn't have the personal knowledge.
And narrated here the gist. He is narrating about the prior demand. The sequence of events.
Does he have personal knowledge about the demand? This PW5? He says that in the complaint it was there. Maybe.
Personal demand to the extent that during the time of preparation, the decoy has said that this is what he has concluded. The gist of his complaint was that he had to get refund of his security deposit from the electricity board. But the dealing assistant, C. Sarangi, was demanding illegal gratification of rupees 50 from him to arrange refund of his security deposit.
Which has the gist of the demand if it could not be proved by evidence, other evidence.
This also corroborates with the evidence of PW6 and 9 also. PW6 happens to be our inspector manners, the IO. And 9 manners is the...
come to page 57. Page 57, 4th 5 line.
I produced.
No, I was introduced. 57. I was introduced with the officer present there, including the magistrate.
Yes.
Thereafter you reading.
I might
have narrated the allegation regarding the demand of
that is the
I might have done it.
Yes, madam. That is.
And he says
that is the reason he has been declared hostile.
Hostile subsequently.
Yes,
hostile here.
Immediately thereafter, madam.
Immediately when he says that I cannot say the accused was there or not, then declare.
Their defense plea.
And insofar as this part is concerned, there is no suggestion. This part I have underlined, immediately I have underlined. Where is the confrontation? Where is the question regarding whether I might have narrated the allegation?
Cross is there, suggestion has been given as far as demand is concerned,
And your lordship may kindly see.
It is not a fact that I have given the.
Your lordship may kindly see 57, my friend.
Suggestion is there.
57, my lord. 57.
Suggestion.
Just a second. Page 57 of your permission. Page 57, my lord. Just on the top of cross-examinations.
Hmm.
Last, I gave 50 rupees to one Sorangi Babu of the office, but I cannot say if the accused was that Sorangi Babu. The accused was that Sorangi Babu.
Yes.
I gave my money.
Yes, and this is their defense claim, my lords, that your lordship has to analyze how far it is acceptable in view of section 20 of the presumption.
Well, there is no direct.
Section 20 of the presumption, you also not needs to have to analyze it, my lord. How far it is
Presumption-
acceptable.
Presumption is
In
can
favor
be
of
operate
innocence.
insofar as the recovery is concerned.
Yes.
If demand, there can't be presumption. You can't presume that she has demanded.
Yes.
Demand has to be proved. Presumption becomes an acceptance stage.
My lords,
When you presume
yes.
that he accepted the money, then he has to explain why he has accepted.
My lords,
That there the presumption comes,
my lords,
not at the demand
my
stage.
lords, the chemical examination has turned positive. That means he has accepted, my lords. Once there is acceptance, section 20 comes into play, my lords.
That there you show me.
Yes, my lords.
There you show me.
My lord, so far presumption is concerned, the basic principles of criminal law is, my lord, presumption is always, my lord, always, presumption is always in favor of the innocence of the accused.
No,
Unless it is proved by clear and cogent evidence.
No, that is a general principle.
Yes, yes, ma'am.
But in the special statute here,
Yes.
once they have proved that the money is recovered,
Not recovered. Your lordship is right. Your
No,
lordship
what
is right.
I am trying to say, his money is recovered.
Yes.
Then the presumption operate against you. You have to make out a case that this was meant for something else.
Yes. Money is recovered. Your lordship is right.
The
But they
reproduction
prove
Whether
that
recovery is proved or not, that has
Yes,
to be changed.
yes.
Show me the recovery.
Yes.
recovery from the accused.
Demand part. See, the problem is demand and acceptance both has to be proved.
Yes.
For demand, for the purpose of demand, you can't bring 20.
Yes.
For the
Acceptance.
you can't 20 for the demand.
Recovery
only.
is there. Yes, ma'am.
So you show me now demand. I understand.
Acceptance is also there. Once acceptance is there, section 20 comes into play, ma'am.
That's what I'm saying.
Yes,
When 20 will operate when in the case of acceptance only. But
Acceptance-
demand you can't bring.
So what I need to impress,
Demand you need to have a positive
yes,
evidence.
means what I need to impress upon your lordship is that when there is acceptance, section 20 comes into play.
Right.
Yes. Acceptance has been
There is
proved through the
acceptance.
chemical wash manuals.
When there is
Hand wash is
acceptance, no
positive.
acceptance.
That means
Then
he has come in
acceptance.
contact with that tainted currency
Then in
note.
the absence of demand, what will be the consequence of acceptance?
Well, section 20 comes into play.
No.
No, section
And
20
he-
comes when there is acceptance. But he
Yes,
says there is no acceptance.
Acceptance is there, my lord.
Who says?
Acceptance, yes, I accept.
Yes.
Acceptance is there. He failed in 20. No
Yes.
problem. But in the absence of positive evidence for demand, even if the acceptance is proved, what is the consequence?
My lord, section.
Therefore, I am saying, show me the demand.
But that's what I was.
Positive evidence. Of
Yes, my
demand.
lord.
Yes.
Become redundant.
Then when
Acceptance you will go subsequently.
my lords, if demand is bereft of the demand, my lords, the intention of the legislature to enact section 20 is to meet such type of exigencies, my lords, where decoy turns hostile or dead in these circumstances. Means if demand is taken in that consideration, then section 20 will become redundant, my lords. Because other circumstantial evidences will be taken into consideration, then has to be inferred, then the conclusion has to come that section 20 comes
And
into play.
PW5, you are independent witness.
Yes, my lords.
The COI gone, independent witness gone.
P5, we are 69, my lords.
Yes, 69. Yes, you are there.
Yes, my lord. The last part,
Gist of
the gist of his complaint.
I
is
read
that-
it. Next.
Yes.
Hmm.
Then your lordship may kindly come to PW6, page 77.
77,
my lords. Unless that piece of evidence of PW5 gets corroboration by
PW6, huh?
PW6, my lords. The last but 4 line.
Who is he? PW6?
He has to be the inspector vigilance, my lords.
Okay.
I will just place the last 4 lines, my lords.
77, huh?
Yes, my lord.
Yes.
Yes. 76, my lords.
76.
76, first para, the last 3 lines, last 4 lines. The preparation was made when myself, Executive Magistrate, PW1, Ulamani Manti, DSP UC Mahapatra, Vigilance DSP were present. DSP Vigilance SK Rai introduced the complaint, Firoz Khan, to us, who narrated the entire case before us in brief, that is demand of ₹50 by the accused from him as illegal gratification for releasing the security amount of ₹500. And with this fine corroboration with PW5, then your lordship may kindly come to PW9 minutes, page 91.
91. Yes.
They are the trap witnesses, my lord.
Yes,
The
yes.
principal witness have torn.
Yes.
That
But
packet.
the middle portion, the sentence beginning with at 10:25 a.m. Page 91.
91. Huh?
Yes, ma'am. The sentence beginning at 10:25 a.m. What you have it? Ma'am?
Yes.
10:25 a.m.
10:25.
Yes. At 10:25 a.m. on the same day, on getting the signal from Kulamani Mahanti, myself and DS Umacharan Mahanti, Pitabas Behra, BB Mahapatra, that is all the members of the reading proceeded to the spot, and we found the accused on the corridor near the staircase where he was detained by us. The informant and the overhearing witness disclosed before us that while the accused was in his seat, 2 minutes back, he had demand of ₹50, which was paid by the informant and was accepted by the accused. And the accused kept the currency note in the left side pocket of his full pant.
Where he was detained as the informant.
Yes.
And the other overhearing witnesses.
Yes.
Disclosed.
Disclosed, my lords. Other overhearing witnesses.
Overhearing witness is that PW5.
My lords, he happens to be PW5. Yes.
Fine.
Lordships are correct. Head clerk.
This will be this will qualify to become a hearsay. Hearsay because of the two evidence which is gone. Hearsay.
And here also he has said that he has accepted. And the next thing comes into play, my lords, when the chemical wash is positive, the factum of acceptance is proved. Once the factum of acceptance is proved, my lord, section 20 crops up. Then my lords has to decide and adjudicate and analyze what plausible reason the accused is presenting before your lordships and whether it's to be accepted or not. Now, my lords, here the defense plea that has been taken is regarding that one, there was mistaken of identity of Sarangi Babu, which my learned senior has pointed out, my lords, which your lordships are also pointing out through PW 2, my lords, page 66.
There was no confusion. Just a minute. There was no confusion for identification of the accused because by the time when the trial was commenced, my lord, the accused must be in the dock. So if he has said that this Sarangi has not accepted anything from me, there was a question of there was two Sarangi Babus. My friend is right that the evidence discloses that there are two Sarangi Babu in that office.
Yes.
But the accused, this accused against whom they have placed the minor charge sheet and who was facing trial, by the time this witness deposed in the court my lord, in the dock, my lord, witness box, the Sarangi Babu was in the other dock, my lord, the other box. So there is no, he should have said that yes, this is that Sarangi Babu who was accepted, who was demanded. He saw the Sarangi Babu. Sarangi was very much in front of him, my lord, in the dock. And while deposing my lord, he said that this is Sarangi Babu.
No, this not this Sarangi Babu, some other Sarangi Babu.
Yes.
Yes,
ma'am.
He has never said. He said even if he has not this Sarangi Babu, some other Sarangi Babu, and he says this man has not demanded, accepted anything from me, and no recovery also from him. So by this applying this presumption, my lord, if there is direct evidence failed, my lord, when the witness, my lord, who the witness, my lord, he has denied. The other witnesses were declared hostile. And the most important part is recovery, which was recovered from PW2, who admitted, my lord, your lordship may kindly see, he admitted that it was recovered from my box.
And let us see the IO's statement.
Yes, ma'am.
Once a substantive evidence,
IO?
substantive
PW6,
evidence
madam.
tells man, IO will
The
definitely.
one which I am reading.
PW6 page 80.
I will definitely speak in favor of the investigation.
No, was there any confrontation to the IO? Where from he has recovered?
PW6, ma'am.
PW?
6, page 76 onwards.
PW6.
IO, my lord, in a criminal case, whatever the IO has conducted the investigation, that aspect only will highlight.
No, see, if he says that
Nothing beyond that.
PW5 says that it was recovered from him because this note, which is the subject matter, was given by one of the consumer. He says. What was your
one thing, my lord, as far as the notes are concerned, they're given by the consumer. My lord, the magisterial witness has compared the notes. What the preparation, during the preparation, my lord's report has been prepared. Number of the notes have been jotted down there. The recovery notes had matched with that numbers, my lords. How can it be of a consumer? Plus, during preparation, your lordship knows the magisterial witness work is to see the numbers, get it jotted down, and during time of recovery, he has to compare it. And when it comes, my lords, to the forefront that it is the same notes, it is the same GC tented notes.
So if I accept PW5 also,
yes,
how come that note has gone to the
Yes.
accused's hand and which turned pink? That is a question. That link is missing.
my lords, it's there in the narration. After accepting the tented GC notes, he went downstairs. Cleverly, he went downstairs in order to exchange it. He exchanged it with the cashier, knowing fully well that he may be in trouble. And at that spur of moment, he was caught, and those notes were recovered.
Exchange was already done or not?
It was already done. That is the reason the tented GC notes were found in that from that PW5, the cashier.
Any people found it.
But it was found in from his pocket. That's the case.
No.
PW9 just come to PW9.
Page 92 minutes.
Last line 92.
Yes.
Last 5-6 lines.
Yes, ma'am.
Mr. Bora, who handed over the note of 50, were taken in the sodium carbonate solution separately and we turned pink color. The pink color solution were collected separately into clean and dry glasses. The same was duly
Here the narration is there.
Full paint of MO2 marked as replaced by another full paint by us.
May I just place
What is
it?
this?
Ma'am,
Full paint
Yes.
of MO3
Yes.
already marked
Yes.
was replaced by another full paint by us. The left side paint pocket of MO3 was washed with the sodium carbonate solution, which turned pink, and the same was collected in the clean and so on. So
My lordship's question.
what is the story?
My lordship's question was how that money went there. What is the sequence? What is the chronology of events? So lordship may kindly come to page 91. 91, my lords, which I was placing earlier also at 10:25 a.m. Lordship have it, my lord?
I'm there.
Yes, ma'am. At 10:25 a.m. on the same day, on getting the signal from Kulomani Mahanti, myself and DSP Umacharan Mahanti, Pitibas Veura, VB Mohapatra, that is all the members of the raiding proceeded to the spot, and we found the accused on the corridor near the staircase where he was detained by us. The informant and the overhearing witness disclosed before us that while the accused was in his seat 2 minutes back, he made demand of ₹50, which was paid by the informant and was accepted by the accused, and the accused kept the currency note in the left side pocket of his full pant. Material object 3.
That is MO3.
MO3. Material object 3 is the full pant which the accused was wearing then. Before we caught hold of the accused, he on receipt of ₹50, this is important, man, immediately hand over the file of the informant to a lady assistant and went to the account section and changed the tented amount of ₹50 from the cash section and came back to the corridor.
Oh.
This is the sequence of what
That
he has
lady
done.
assistant has not been examined.
After catching hold the accused, while I disclose my identity, also disclose the identity of other persons belonging to the raiding party to the accused. When I challenged the accused that he has received ₹50 as gratification from the informant, he became restless. Plus, this is the
Then in
sequence
the
of
light of this, PW5 may be correct.
Yes. Now, this is what he cleverly did immediately after getting it, got it exchanged. And then he says that this money has been recovered from consumer. If at all that has to be believed, my lords, how those currency notes are matching with the tainted GC notes that has been noted in the preparation report.
Yes, anything else?
Yes, my lord. Your lordship may kindly see that so far the exchange story is concerned, my lord, when the witness, whether we will go in a circuitous way, my lord, when directly the evidence of the witness, my lord, the PW2, my lord, the deco witness, if he has said that I do not know the accused at all, and he has also said that there was no demand by this accused who was present, and there was also no acceptance, he has not given that. Well, if that witness doesn't say at all, and the second witness, my lord, the witness from whom PW2, my lord, from whom the possession, the amount was given, my lord, no suggestion was given that it was exchanged by him. And
you have somehow you have a case in so far as demand is concerned. Acceptance, you don't have a case at all.
So for demand is concerned, no demand. And so for acceptance is concerned, my lord, I will also convince your lordship. I will convince your lordship. So for acceptance is concerned, my lord, I have a strong
Acceptance for PW5, the story which he says that the money was given by the customer and all, that goes against you.
Yes.
In view of the evidence of PW.
If two views are possible in a criminal case, the view that supports the defense has to be accepted, my lord. That is the principles of golden principles of criminal jurisprudence.
No, it's not two views.
Yes, my lord.
It is only one view that you have changed the note.
I will convince your lordship. I will convince your lordship. No question about taking accepting.
You concentrate on demand. Demand you can come out. If you can prove, see demand, I am still have a doubt.
Right.
See demand, you don't have a direct evidence.
Admitted.
The one which you have read it.
Yes.
That is a hearsay.
Yes.
Hearsay from two witnesses.
Yes.
And both the witnesses have not supported the prosecution. So demand part goes. Even if you exclude the acceptance part.
Even if they are hostile witnesses, your lordship knows your lordship has to separate the grain from the shafts, my lord. Entire hostile, if he becomes hostile, entire witness cannot be discarded. That has some corroborative value, my lords.
That's right, but in you corroborative value, it's all right. But insofar as demand is concerned, how will you draw corroboration? From where?
My lords, PW.
You are trying to draw corroboration from
5, 6, and 9, my lords.
But he says that I have heard it from these two people, those who are done hostile.
Yes. No, my PW 5 says he had heard directly from the complainant. Your lordship may kindly come to page 69 once again.
The same complainant is not supporting you. Hearsay.
There was that portion which
from the person from whom these witnesses have heard.
Yes.
That person comes to the witness box, says that no.
Means can hostile witnesses, basing on an evidence of an hostile witness, all the other witnesses will be discarded, my lords?
Others have also hostile.
When they have deposed on oath in a court of law, my lords.
If your witness says that X and Y, I have heard from X and Y. If the X and Y turn hostile, the hearsay evidence has to be discarded. That's the difficulty with you. That's the only difficulty with you. Otherwise, you have a case.
And then section 20 is there for our.
Under the aid of 20, demand you can't have a
demand is not a sine qua non for section presumption of 20 minutes.
That's right, but you have to see the consistency of law. Exactly. If in a trap case, recovery is made, acceptance is there.
Yes.
And the owner shifts right away to him.
Yes.
To prove why has he accepted it.
Yes.
For that purpose, 20 is utilized.
I am obliged, my lords.
Not that for 20 is utilized for demand also.
No, my lords.
Utilized for acceptance.
Well, bereft of the demand also. Bereft of the demand, my lords, when section 20 comes into play, in my humble submission, he fails to give a plausible reason. Rebuttal is not admissible, my lords.
But I think you need to have positive evidence for demand. Acceptance,
my lords.
Acceptance is proved.
Acceptance, then section 20 comes into play, my lords.
20 comes into play. No problem.
Yes.
But even if acceptance is proved with 20 or without 20, minus demand, what is the consequence of that?
Well, as far as section 20 is concerned, demand is not a sine qua non for that. Bereft of the demand also, section 20 comes into play. This court has to, and basing on other circumstances.
Judgment. This is the issue. No, you have to address.
I will address.
This part you have to explain. And one more thing, in equity doesn't have role to play. Still 50 rupees, and see, this is a case of
99.
90. And this man is about, what is his age?
Age कितना होता है?
About?
Age कितना होगा?
45.
45 in the year
99. 75.
70.
These two things also you keep it in mind.
Let's
find out some way out to give equity. Find out some way. It's the worst case, you can't find out any way. It's a watertight case.
Yes.
Then you have to convict. There is no way out.
That case, if
there is some leakage somewhere, let us give the benefit of it.
Well, as in that case, if I say no, it will be contemptuous, and if I say yes, it will be a perjury.
So by this.
But you just look at it that if there is if it is a watertight case, then he has no problem. But
he
under
has
the,
problem. If it is
he has a
after-
problem. But in the, under the age of 20, don't try to, establish.
My lords, in fact, in my humble submission, my lord, section 20 is there to meet such type of exigencies. Like where the decoy or overhang which just turns hostile or they are no more.
If the accused is very young, then utilize 20. Otherwise, come with the full evidence.
With utmost respect to the Honorable Court, the Honorable Court by the meantime also has examined and whether your lordship also can visualize whether this is a watertight case.
Yes, I understood it now,
Yes,
but
ma'am.
this is the area. Yes, yes, sir.
Item 170, this is extended appeal. My lord, Chaudhary is ready, then.
If he is ready, then I have no problem.
Well, the problem is this side there are many people, this side only one people.
For that reason, I am saying image that with that it can be taken up one.
We will discuss and we will tell him.
You discuss and mention it. Whenever he is ready and both the side ready, I have no problem.
Next week, any date.
Next week.
Is a appeal.
Appeal.
11, if I'm not wrong. 11, no? 2011.
2012.
Well, 12.
But in this case, just see,
Next week,
because it's 99 case.
Yes.
We have to finish up.
14, my lords, 14.
Substantially heard?
Yes, 14th we can dispose it.
14th August.
Yes.
And
at 12, 15th for now.
No, before 14th.
My lord, my
Let
learned
it be
senior
that-
is saying after 15th also.
12th or 13th.
Minus 20.
12th or 13th.
Yes, lords. He says after 15 also he's ready for that. So 20th, my lords. 20th of August.
Okay, 20th.
Great.
But come with a written note.
Yes, ma'am.
And you
Yes,
ask your junior to give a small note.
My case will be posted on 21st or 13th.
Let it be there. You prepare and tell him. I'll pick up the file anytime. When nobody is there, I'll argue. You can hear it. That's better. Let it be there. Today may not be possible.
Why I am fixing this contract?
Okay, day after tomorrow. Let it be there day after tomorrow. I know that you have matter. One matter, you are the evacuation.
44, 46, I am also praying for day after tomorrow.
Let it be there, you
Let it
come.
be there.
I'll take it up, no
Yes,
problem.
Day after.
You, day after tomorrow you come.
Yes.
I will not take up,
Yes.
but let it be there in the list.
Yes.
I'll take on day after. And you are there in evacuation too, madam.
Yes. Both the matters. Yeah.
And please give the particulars so that the day after tomorrow they will ready.
Okay.
3 matters, small matters.
Mr. Simchani, Mr. Simchani's vast experience can be placed into service in many matters. Amicus
In absentia also I have appointed him evacuation couple of matters.
He says he has adequate strength to shoulder more
I
responsibility.
know, that's I am doing it. I told you in 1 or 2 matters that to inform him. I have appointed. I don't know whether.
Yes, he has informed.
My lord, that let it be next week, day after tomorrow already of
Okay,
3
next
matters
week,
are
I don't have any problem. Week commencing 5th.
Yes. But his matter we will take day after tomorrow. He has been, he has been coming every day mentioning it.
Next week, my lord, better, my lord. The board is very taxing this week, my lord. I hope my learned friend will understand this. I will talk with him. I will try to convince him.
You,
Yes.
fix accordingly.
Yes, ma'am.
Okay. Thank you. Password. Yes.
Item 100.
Yes.
May it clear lots. The petitioner is seeking he sought discharge from the lower court. That having been rejected, he has approached this honorable court.
Yes.
It is a case under sections 7. The charge sheet has been submitted alleging commission of offences under sections.
Dada microphone that is. 7 and 12 of the PC Act.
Yes.
That has been rejected. Your Lordship will kindly see
7 and
7 and 12 of the PC Act.
come to the order.
My Lord.
MP order.
91, page 91.
Yes.
Hmm? No, no, order is from 91, no?
Yes.
Ultimately, we are challenging the order framing charge at page 98. No, charge is framed, but
No, his application
yeah,
for
it has-
discharge has been rejected.
discharge
That
petition,
starts from
rejection of
page
that,
92.
that
Yes.
has to be considered.
Yes. What are the points?
First, number one, he is not a public servant. Number two is that he has no role in the entire thing. Because the prosecution case is the vigilance inspector. He conspired to get money from the accused, not accused, sorry, from an officer by threatening him that, yes, if you pay me, then I will see that you are not framed in the case. That is, and I know so many persons, I know so many authorities, I will see that no action is taken against you. He reported the matter to the vigilance, and then trap was made, and thereafter this case has been registered.
What is that?
And in the
role
mean-
ascribed to you?
And in the meantime,
What is the role
yes, the role ascribed to me is that I paid some money. I took it from the person, the complainant, and supposedly paid it to the inspector. I am a private person. In fact, an unemployed youth.
Yes.
May I place the order, ma'am? Page 92.
Yes.
Both the accused persons are present in the court today and file their respective hajiras, so and so. Second para. It was argued by the learned counsel for the accused Manasi Jana that Manasi Jana is the IO, police vigilance inspector, who is the kingpin. They are, according to the prosecution, is the kingpin. IO has miserably failed to bring any material evidence with regard to demand and acceptance of any bribe by said accused from the complainant. The law does not permit for keeping cash more than 2 lakhs, but the IO has miserably failed to extract the truth from the complainant as regards the source of keeping cash of 10 lakhs with him at a time beyond the prescribed time limit, to give it as bribe. The IO has also failed to establish that the accused Manasi Jana had demanded and accepted any bribe from the complainant. Though a time petition is filed by the learned counsel for the accused Mukesh Sahu is the present petitioner. Mukesh Sahu, but it is rejected, being not pressed. It was argued by accused Mukesh Sahu that the IO has falsely implicated him in this case. The IO has failed to bring any material evidence with regard to the alleged demand and acceptance of bribe by him. The IO has not collected any satisfactory evidence with regard to keeping up huge amount of by the complainant beyond the prescribed limit. So he submitted to discharge him from the charges leveled against him. On the other hand, the learned additional special PP vigilance strongly objected to both the petitions dated 7/9/23 and 14/9/23 filed for discharge of the accused persons. He strongly contended that the court, at the time of consideration of the charge, is not required to examine the pros and cons of the material available on record. The court only requires to see whether a prima facie case is made out from the materials on record or not. Even a strong suspicion regarding involvement of accused is sufficient enough.
Come to para 5. Before analyzing the material on record,
Before analyzing the material on record, I perused the law laid down by the apex court as well as our honorable court with regard to framing of charge. In case of CBI Hyderabad versus K. Narayana Rao,
reported in 2013.
Okay,
One.
all the judgments are discussed and para 6. Now let
Now
me
let me
examine.
examine the materials on record in the light of the law laid down in the above decisions. Admittedly, at the relevant time, accused Manasi Jana was working as vigilance inspector in the Vigilance Division, Sambalpur, and complainant Lakshmikanta Padhi was the chief construction engineer, Western NH Circle, Sambalpur. The statement of the complainant Lakshmikanta Padhi recorded under section 161 CRPC reveals that on 17/3/22, accused Manasi Jana contacted him over cell phone and called him to attend her office for some inquiry. As he was busy in some official works, he could not visit her office on that day. After repeated calls on 24/3/22 at about 8:45 p.m., he went to her office and met her in her official chamber at Sambalpur Vigilance Division office. Accused Manasi Jana informed him about an allegation lodged against him and told that his house will be searched in the month of April. Said accused also told him that his case can only be closed by government and one Sahu Babu, the accused, who is an OS officer, would help him. Accused Manasi Jana in his presence talked with Sahu Babu, the co-accused, over cell phone and gave the cell phone number of Sahu Babu to him and directed him to contact said Sahu Babu. Investigation reveals that name of said accused is Mukesh Sahu, who is not a public servant. This yes, Mukesh Sahu, the petitioner, who is not a public servant. The statement of the complainant also reveals that he contacted Sahu Babu, the co-accused, over cell phone, and on being instructed by the co-accused, he went to Bargad, met with him, discussed with him, who informed him that he has good rapport in the government and he complainant has to pay a good amount for closure of the case. He, complainant, informed accused Manasi Jana about her meeting with Sahu Babu, the co-accused, and accused Manasi Jana told him that said Sahu Babu is the only person who can help him and he, complainant, must obey his direction. After some days, on 11/4/2022, Sahu Babu, the co-accused, contacted him over WhatsApp calls and demanded to pay rupees 20 lakhs as bribe to close the case. He, complainant, expressed his inability to pay such a huge amount and contacted accused Manasi Jana over phone and as per her direction on 12/4/2022 at about 2:45 p.m. met her near Ekamra Park, Bhubaneswar, where she told him sternly that after the payment of rupees 10 lakhs to Sahu Babu, the co-accused, she will forward a closure report of his case and rest will be managed by Sahu Babu. Getting no other option, he, complainant, agreed to such illegal demand against his will and consent. On 17/4/2022, accused Manasi Jana informed him, complainant, that Sahu Babu, the co-accused, has agreed to accept the amount in 2 installments. The statement of the complainant further reveals that on 4/5/2022.
Yes, I read it.
My lord.
Para 7.
The aforesaid statement of the complainant recorded under section 161 CRPC normally corroborates the allegation of the affair dated 12/5/2022 lodged by the complainant before SP Vigilance Cell Cutter. The truthfulness of the allegations of the affair can only be scrutinized only after completion of trial of the case.
Yes, what is wrong in it?
It only on the basis.
161 statement is there.
One
FIR is there.
Yes.
And there is a story, it was called, Sahu Babu called, and he went to Bargad and discussed 20 lakh rupees was demanded, reduced down to 10 lakh and all this.
The only thing is that it has been simply based on the statement of the main accused, Manasi Jana.
Main accused Manasi Jana and the complainant. 161 statement.
This petitioner has no role in demanding. And he is not a public servant.
That will be tested in the...
No, he is not a public servant.
Maybe.
He is not a public servant.
7 is there.
7A.
7A is there.
No, 7A, they have not LS 7A. 7 and 12. So 7A is not there.
Page 98.
Page 97. 7A. 7A.
My, yes,
7A.
7A is,
7A 12.
charge sheet was submitted only for 7 and 7.
Maybe charge sheet, but now charge is framed for this. Don't think you have a case.
Well, he
I'll
had,
keep everything open to be argued at right stage. That's the only thing can be done.
he has no role,
No
absolutely
role
no.
or there is a role, there is a story put forth by the complainant. 161 statement is there. There is an FIR, and vigilance officers are involved, and we don't know what is his role. What today, prima facie, it look there are allegation under 161. And your only defense is why the complainant could not explain where from he got 10 lakh. That's a different story where from he got 10 lakh.
No, that is one of the technical grounds.
That is
Technical grounds that
how
is
he kept beyond 2 lakh rupees, how he kept 10 lakh rupees with him. Those things are cut no eyes for the
that is one of the technical grounds. But fact remains.
I will reserve your right to agitate all the points at the appropriate stage. Right on. The present.
How can I also देखियो हम चेष्टा करेंगे
दादा आज
चेष्टा कले भी कौन होगी
दादा एंता कले केंता हो दादा
आसु चेष्टा करें
हम आगे आज पर किसी डिस्पोज ही नहीं
ए आई दिने न होला कोन
आपण चेष्टा कले you can't improve the case.
देखियो हम चेष्टा करिबी हां चेष्टा करिबी किछ
अच्छा दादा मुके दादा मुके
काली नहीं नेक्स्ट वीक
नेक्स्ट वीक
आगे
कोई बात
आगे
नेक्स्ट charge is already framed. You can't tell it.
देखिबा जदी कोन
Partly heard.
आगे हां बस
Partly heard. But you don't have absolutely you don't have a case. Yes.
Let me try make
Fine.
106.
आ तापरे इठी आज्ञा संग्राम दास थिले इट विल बी मच मोर डिफिकल्ट
दादा एंता कले केंता हो मु गुटे वर्ड भी कहनी दादा
दरकार नहीं
Your presence is making so
we respect him because he's a man, epitome of honesty. Whether any election in High Bar Association or Bar Council, wherever he's a sweeper. He cleans up everything. A man is full of integrity and honesty.
Greatly thankful to them.
They are the assets. They are the assets.
In all High Court Bar Association, Chief Election Commissioner after session, Mr. Pujari. In Bar Council matters also, when he was there, he cleaned up everything. People are scared of him.
They are the real assets.
Some of the honorable judges of this court might also publicly said that when Mr. Pujari is there, we did not look into the record.
Of course. Yes.
106.
106.
Personal matter, but the council not appearing, 7-9. Are 2 years?
Yes.
Madam.
Yes. And nobody is appearing?
Nobody appearing. First hour, nobody appearing.
Appoint her as a MAC. I am appointing you as a MAC.
I have not completed 5 years.
Is there any age qualifying experience? You don't have 5 years, therefore you are the fit person. After 5 years, you will not have time. See the right guy. Mr. Ragada is there to help you. And come this week, anytime you prepare and come and tell me. Supply the copy here. Give it. Yes.
Remain in the list.
Weekly list will remain and copy will be supplied. Yes. Next. 33-0. Huh?
I'll get a little more time to prepare. Next
No
week.
problem. Next week, no problem. You can take assistance from Mr. Ragada.
He is doing very well.
They will do definitely. Yes, Mr. Boss, 30, 30. Paper book is there?
Here,
If you have a good case, argue. Otherwise, don't argue.
I have a very good case.
All the best.
Yes.
Now here, the appellant is accused by the learned trial court, has been convicted by the learned trial court under section 13(2), section 13(1)(b) and section 7 of the PCA. And he has been sentenced to undergo RI for 2 years and pay a fine of 2,000. And in default, RI for 6 months for his conviction under 13(2) of the PCA. And to undergo 1 year and fine of rupees 2,000 in default. To undergo RI for 6 months under section 7 of the PCA. This sentence is to run concurrent. The prosecution case is, madam, one Prabhakar Malik, PW1, filed a mutation case bearing MC number 362 of 1997 before the Tahsildar Mahakalpada to mutate 75 decimals of land in his name after purchasing from one Sridhar Malik in the year 1991. PW1, after receiving notice from the office of the Tahsildar, when appeared the accused, who was a mutation clerk, demanded rupees 1,000 for finalization.
You are the mutation clerk.
Yes.
Yes.
Demanded rupees 1,000 for finalization of the case. Otherwise, he will get dismissed in Lokadal at Kendrapada. Finally, the accused agreed to receive 500 from the informant, but the informant was not agreeing to give 500 as right. So on 19/12/97, he lodged an FIR before the Inspector of Vigilance Kendrapada, PW6, and the trap party was laid on 20/12/97 to catch the accused. The accused defense case is that one Noto Mohri of Mahakalpada Tahsil had taken 1,000 from the accused much prior to incident to supply rice to the accused. When he did not supply the rice nor return the money, there was a quarrel between the accused and that said Mohri Noto. Just 8 to 10 days prior to the incident, where Noto threatened to accuse to teach him a lesson, the accused denied about accepting the money as illegal gratification, and this trap was laid. But my case before your lordship is that the amount of rupees 500 which has been recovered from my pocket as a trap is not the money which I demanded for completion of the mutation case. This is the money given by Noto Mohri to PW1 in lieu of my 1,000 rupees which I have given to purchase rice. So the case before your lordship is that first the prosecution has to establish that there was a pending mutation case. Unless the mutation case is pending, so question of taking money doesn't arise. Man of trap may be there, hands turning pink, everything is okay. But the basis of the case is to be there. There has to be a mutation case which is pending on the date when I was trapped.
Yes.
Unless I do that, unless you pay me money, I will not do the case. If your lordship may kindly see Exhibit 1. Exhibit 13.
Page.
It's not there in the paper book, my lords. Lordship needs to see in the LCR.
LCR, your lordship.
This is the new.
I've got a copy, I can provide it.
This is the mutation case record.
Yes.
Exhibit 13.
Exhibit 13.
Exhibit 13.
Yes.
Yes. Tell me what happened.
My lord, mutation case was initiated on 34/97. Certain dates are important. I've given in my note, but
Yes.
I'll just address your notes. On 22/5/97, the mutation was allowed. Trap was laid in the month of December. Mutation was allowed in the month of May.
May date?
Well, that is 22nd of May, 1997.
22nd of August.
August, sorry, I'm sorry, 8. You are correct.
1997.
97. Mutation case was allowed. And after mutation case was allowed, the record has to be consigned to the record room for correction of the record and putting it in the site. That site was not there. The record will be corrected and it will be given to him. There was a deficit court fee of rupees 16. That was within the knowledge of the informant that 16 rupees is due because he had signed the order sheet
that 16 rupees is due. Unless he pays the 16 rupees, the record cannot be corrected. But the case is like that. Mutation is to be passed by the Tahsildar or additional Tahsildar. I'm the clerk in the office. So on the date of laying of the trap, the mutation case was already disposed of.
Because it is in August it is disposed of, and to December the trap was. Yes.
So August when it was disposed of, and 16 rupees fee was not deposited, the mutation record could not be corrected. Am I clear?
Yes, yes, I am.
So on the date when the demand was made or the trap was laid, there was no existence of mutation case. Because once an order is passed, appeal period.
What was the demand for?
Demand for was to allow his mutation case.
For finalization of the mutation case.
Finalization of.
Yes.
There is a difference between finalization and allow.
Finalization and allowing is
You
same.
yourself said they of 16 rupees.
Yes.
So the mutation proceeding was not finalized.
Mutation proceeding was finalized. 16 rupees was not paid, for which the correction in the record of right could
The
not.
mutation means the entire mutation
No.
till it is
No.
completed.
My lord will see the Orissa Survey Settlement Act, where it says the record after it mutation proceeding, the mutation manual is there. Once the mutation order is passed, he has to deposit a fee for correction of the record. Once the mutation order is passed, it cannot be recalled back unless it is set aside in an appeal.
Why for your demand?
That is the case that I have not demanded. There was no demand.
But what is the case of prosecution? You
Prosecution.
demanded for what?
I demanded for finalization of the mutation case.
Finalization of.
Yes.
What was you are supposed to do what?
I
according
was
to prosecution?
supposed to just put the file before the Tahsildar, place in the records of the inquiry, and he will pass an order of mutation.
Which in the August it had done.
It was done in the month of August. So once the Tahsildar signs the order,
Your case is there was no occasion for me to demand the money. That's
Demand
what
the
you
money.
want to say. Because mutation proceeding was already concluded.
due to want
In
of
22nd, this is, yes.
due to want of 16 rupees, the record could not be corrected.
So there was no occasion for you to demand the
Demand
money.
money.
Yes, next.
And PW1,
Hmm.
your lordship will see, PW1 has become hostile. Who
Okay.
have lost the complaint. Your lordship may kindly turn to paper book at page
34.
34. My lord may kindly see the last portion of the evidence in chief. One notter out was looking
34,
after,
huh? 34.
Yes. One notter out was looking after my case, but then I did not know the accused Mollababu, Mohori Nottababu, told me for finalization of my case, rupees 1,000 will be required.
Yes.
Then a petition was filed by the special PP to put him leading question. Your lordship may say, see page 35 at 5th line from top. I cannot say how they knew about the receipt of money by the accused. Then paragraph 3. It is a fact that time of lodging of the report and recording of the statement by the IO, I did not state anything that Mohori Nottawara asked me to pay money for my work in the Tahsil office. I did not state before the IO that the accused was giving me threat from time to time to pay money to him. Otherwise, to send my mutation case to Lokadal for disposal. My lord, why I stated before your lordship that on 22nd August, the case was finalized. Due to want of rupees 16, the record could not be correct. It is a clerical job, nothing relating to mutation. Once the mutation order is passed, and if the authorities do not have a power of review, because your lordship knows review is a creature of statute. Review who could have filed?
But mutation is not carried out.
Mutation was allowed.
Allowed, not carried out.
Recording was not carried out. That I will demonstrate from evidence of the Tahsildar. I'll come to
That
it.
is the case. You have demanded the money for the purpose of mutation to be done.
Done.
That's what
Mutation
you.
was done. Mutation was done.
Direction to do the mutation is done.
Done.
Mutation as such is not done.
Mutation is due to want of 16 rupees, it was kept pending. And who will pay that 16 rupees? That is 16 rupees, I will not pay. He has to pay. So once an order is passed, my lord,
Yes.
I cannot set it not that order.
Yes.
It is a clerical job. Then your lordship may see, otherwise I'll send the mutation case to Lokadal for disposal. I also did not state to the IU that the accused told me to dismiss my case by approaching Tahsildar. I did not state before IO that I had received notice of the Lokadal from Tahsil Pure, and I was told by him to meet the accused on the next day. So he denied it. Then prior to cross-examination by defense, prior to 2012-97, I never went to Tahsil office. I did everything through Mohori Nottababu. In connection the mutation work, I have paid 500 to Nottababu. He did not do any work for 6 months. Prior to 3 to 4 days of 28/12/97, I have been to Nottababu and he told me to come on 20/12/97 for my work. On 20/12/97, I went to Nottababu. He gave me 500 rupees kept in a paper to give the said money to accused Mollababu. He is the petitioner.
You are the Mollababu.
Mollababu. Till then, I did not know the accused. Your lordship may kindly mark point. Then after knowing Mollababu, I gave the said money to him, stating that Nottababu has given the money and Mollababu kept the money, after which the vigilance people came there.
Then Nottababu had given the money.
Yes.
From Nottababu, there was a deal with you.
Deal.
That rise.
Nottababu was never called to the dock to prove the prosecution. Thereafter, Exhibit 1 was lodged by me, being dictated by vigilance officer. All the contents regarding demand of money by the accused were mentioned as per the direction of vigilance officer and not per my version. Though Exhibit 1 was written on 20/12/97, the date was given as 19/12/97 as per the desire of the vigilance officer. In connection with this vigilance case, I did not go to vigilance office. I did not lodge any report. In connection with my mutation case, I did not have any direct contact with Mollababu, and he did not demand any money from me. The preparation report Exhibit 2 was also written in Tahsil office and not at vigilance office. I gave money to Nottababu and I did not give any money to vigilance officer for purpose of flat.
Right.
I was examined by the vigilance officer and I told the vigilance officer, last 4 lines. I told the vigilance officer that I paid money to Nottababu. Nottababu gave the money to me to give it to Mollababu, and all other facts which I stated are false. Mollababu never gave me threatening not to do my mutation work if the money is not given to him. So PW1, who is the triumph card of the prosecution, fails. Now your lordship may kindly turn to the next page, at page 38.
Yes. Pramod Mahapatra.
Pramod Kumar Mahapatra. I know the accused standing in the dock on 20/97. I was junior agriculture officer of such and such. On that day, as per the order of my higher officer, I had been to Vigilance Inspector Office, Kendrapada. Then your lordship may kindly see the next page at page 39 towards middle. Then the accused was asked by the vigilance officer to have received bribe money. I cannot say what the accused answered. The seizure list, last 3 lines. The seizure list of the recovered money of rupees 330 and the file and different documents is identified and marked as Exhibit 6. He also turned hostile because in cross-examination by prosecution, your lordship will see at paragraph 3. After 2012-97, I was not asked anything by vigilance officer and my statement was recorded. So also prior to 20/97, it is not a fact that I was examined by IO and gave the following statement before him that Prabhakar Malik, complainant, told that the mutation clerk Niranjan Malik demanded 500 as bribe and unless the money is given, he would put case on the complainant in loka adalta. It is not a fact that the accused explained his complaint before us at the place of preparation and by saying so.
Come to 41.
Yes, paragraph 4. In my presence, no money was produced by the complainant. The Mohori who accompanied the complainant was the leading person to the trap party. I cannot say that after reaching near Tahsil office, if the Mohori accompanied the complainant and others to
This Mohori was examined.
No, that is the case. If the Mohori would have been examined, my lord, then prosecution could have made out a case that money was through him, money trail was through him. Because the informant says that I have never seen Manoval.
Yes.
I have never met him. He has never threatened me. I have never gone to Tahsil office. I do not know what the Mohori went to place for preparation and detection. It is not a fact that I was called to Tahsil office after detection. When I reached the place of detection, the hand of the accused were caught and ₹500 was there in the hand of the accused. I do not know what happened prior to this in the place of detection. Detection report was prepared in Tahsil office, Mahakalpana. He also fails. Now your lordship may kindly turn to the next page. Prosecution witness number 3, Ajay Kumar Mahanti. On 20/12/97, I was working in the office of Commercial Tax Department. They had accompanied. There, the vigilance staff Pramod Kumar Mahapatra.
He also turned hostile.
He also turned hostile. I was
who has supported the prosecution?
Yes, I'm coming. I was examined by IO and only my name and address was ascertained from me and no other statement of mine was recorded. It is not a fact that I have given galling statements before the IO. Next page, page 43. That I was engaged, fifth line. I was engaged as overhearing witness to overhear the conversation between complainant and the accused and to see transaction between complainant and accused. That preparation report was prepared on which I signed, but I do not know the contents of it. The signature is marked Exhibit 2/3. That after reaching Tahsil office, I, along with the complainant, went inside the office and found the accused was staying at a distance of 12 cubics. That by seeing the complaint, the accused required whether he had brought money or not.
Yes.
Then, your lordship may kindly turn to the next page. I cannot say regarding seizure of any articles, only signatures on seizure list identified by mark exhibit such and such. It is not a fact that I was all along present starting from preparation till detection and had seen the entire thing and seizure, and I am deposing falsehood only to help the accused. Cross-examination. Now I cannot identify the complainant who went along with me for detection. I did not see him nor him prior to occurrence, but the time I reached the place of detection, the money was kept on the table of the accused and vigilance police was present. Police officer did not tell me regarding recovery of money. Now this your lordship may see the evidence of the Tahsildar
PW4.
PW4. He was the person who had passed the order of mutation. There, your lordship may kindly turn to page 40. From top, my lord may skip 5 lines. Registered sale deed. Your lordship has got it. Registered sale deed, and he applied for mutation in April 1997. Thereafter, notice was served on the party and the case was disposed of by me on 22/8/97. Your lordship may kindly mark the word disposed of by me because Tahsildar has to dispose of, not the mutation thing. After disposal, 45 days time was given to the other side for preferring appeal. That is as per the mutation manual. Thereafter, the record goes to the record room in case no appeal for
What is disposed?
Yes. Disposed. Disposed of by me. Now
in December.
Now your lordship may kindly.
No quota was issued to the complainant.
Thereafter, the record goes to the record room in case no appeal for issue of quota. By the time of trap in December 97, no quota was issued to the complainant. After time limit, the case record was not sent to the record room by the accused volunteers due to pressure of work and shortage of staff as it was a new tahsil. He also clarifies that why it was not said. Then your lordship may kindly see the cross-examination. I remember that during my time, one Dr. Rao was the Mohori. He looks after mutation cases of different cases. On the day of detection of this case, he was present in our office. Prior to detection, we never suspected the conduct of the accused clerk. Rather, he is a good person. There is no allegation before him by anybody against the accused prior to occurrence of the present case. So, my lord, your lordship, my lord will pass an order.
No, not Babu's presence is endorsed by this Tahsildar.
Yes, endorsed by him.
Now, what else?
My lord, I'm giving one example to myself. My lord passes an order. Suppose the staff doesn't upload it, and I do not take a certified copy. Due to some technical snag, it is not uploaded. Will it be proved that the case is not closed? Will it not be said, can I not say that my lord has closed my case?
They would be arguing that the patta was not issued, therefore that was being.
I will answer it. My lord,
because the mutation case is culminated into issuance of patta.
Yes,
and
then it is
correction of
closed.
ROR.
Then it is closed.
Mutation once allowed. That exhibit 13 your lordship may kindly see again. I will take to exhibit 13 again. So this was
therefore, I have highlighted that point, disposed of.
Disposed.
Tahsildar said disposed of.
Yes.
Yes.
Then PW5 was the inspector of vigilance. In the cross-examination, your lordship may see at page
All the vigilance officials have supported the case of vigilance, and all the independent witnesses have not supported. Early in the morning also the same situation was there.
The Tahsildar, though supported the case that there was a trap, but said that I have disposed of the.
And here the difference is section 20 in the attempt of rebuttal presumption. He has put up a story that he has received money from Notababu. For Notababu, he had a dealing with that. And let us see 313.
Yes.
Yes.
Page 30, months.
30.
Yes. Starts from page 30.
That is my consistent case.
Defense question is question 14, my lords, page 32.
14.
Yes. Question number 14, page 32.
Notomorious. Mote chawlo deva pe puchani the. Okay. Specific plea.
That has been taken.
For rebuttal presumption.
Yes.
Okay. And he substantiated through the witness.
Yes.
This is there.
Yes.
The story is there.
Now your lordship may kindly see exhibit 13. If it is available, I will give a copy just. Your lordship may see.
What do you want to say?
Here, that 16 rupees which was due towards enquiry fee, here the complainant had not paid. And the complainant's signature is there on the record sheet that yes, 16 rupees is due. So once he pays 16 rupees.
Where do you want to take your case?
By
saying that?
I want to take my case that there was no basis of laying the trap. There was no basis to file a case against me. There was no mutation case pending on which basis I was trapped.
But showing that you create again doubt for your own case. Rest there. And yes.
As far as the demand part is concerned,
Non-payment of that 16 rupees still survives the petition proceeding.
Correct.
That is what their case is. Why are you insisting on that?
Case is closed.
Why are you insisting that part?
Hello.
That would be their case.
Yes.
They would be saying that PA disposed of. However, since 16 rupees was not paid, still that was survived.
Yes.
And that plea you are demanding the money.
Bereft of that even, if your lordship may kindly come to section 7(1)(d) of the PCA. CORAM.
Old.
New matters.
This incident taken place when?
Incidents of 1998.
98, yeah?
Convicted under the new act only.
New act?
Yes.
Yes. Section 70.
7(d).
Okay.
That is the explanation part I am relying upon. Explanation D.
7D, D for
Yes.
release. Read it out. Not there.
D minutes. Explanation D.
Yes.
A motive or reward for doing.
Hmm.
Or should we have it minutes?
Motive or reward of doing.
Reward for doing. A person who receives a gratification as motive or reward for doing what he does. This is important. Minutes. What he does not intend or is not in a position to do. Even if he is not in a position to do.
Even then he may say that I have
Yes,
a contact,
yes,
I'll get it done.
Yes, you give me.
Whether that work is there or not is the.
So therefore that submission fails, minutes. So not in a position to do or has not done comes within this expression. And this is covered under section 7. Even if he is not in a position to do that work.
But here is a case where he says that it was known to him because he is it is his petition, mutation petition.
Then
so he knew that this clerk could have been done.
Yes.
He could have done.
Yes, but the submission was made that no work was pending. This is what they want to canvass. That as no work was pending, there was no occasion of paying. This is what they want to canvass before your lordships. Then if your lordship may kindly come to the 313 statement. Once again, question 14. Page 32.
Noto Morier mote ଚାଉଳ ଦେବା ପାଇଁ 1000 ଟଙ୍କା ନେଇଥିଲା
ବହୁତ ଦିନ ପର୍ଯ୍ୟନ୍ତ ମୋତେ ଚାଉଳ ଦେଲା ନାହିଁ କି ପଇସା ଫେରେଇଲା ନାହିଁ। ତେଣୁ ଏ ଘଟଣା 8 ଦିନ ପୂର୍ବରୁ ତା ସହିତ ମୋର ଝଗଡ଼ା ହୋଇଥିଲା। ସେ ମୋତେ ଦେଖିବ ବୋଲି କହିଥିଲା।
ଦେଖିଦେବ ବୋଲି କହିଥିଲା।
Then what is this important?
ଘଟଣା ଦିନ
ଗୋଟିଏ ଲୋକ ଯାହାକୁ ମୁଁ ଚିହ୍ନି ନଥିଲି ମୋତେ 50 ଟଙ୍କା ନୋଟ ମୋହରି ଦେଇଛି ବୋଲି 500 ଟଙ୍କା ନୋଟ ମୋହରି ଦେଇଛି ବୋଲି ଟଙ୍କା
2-3 ଦିନ ପରେ ଦେବେ ବୋଲି
କହିବାରୁ ମୁଁ ଟଙ୍କା my submission is that in spite of being a stranger presenting him with the money, he has accepted it. Then if your lordship may kindly come to page 2, my lords.
And he says that somebody
yes. Who gave, he doesn't know.
No, he said unknown person.
Unknown person, man. Man, so unknown person comes and he gives him money and he accepts it.
500.
Yes. Then your lordship may kindly come to page 40 minutes.
40.
Yes. No, before that, the lordship may kindly come to PW1, page 34. Even if he has been declared hostile, lordship may kindly appreciate the evidence the way he has given. In the cross-examination by the prosecution. Page 34. Para 2.
Yes.
My lords have it, not?
FIR was written.
FIR was written by me as per the dictation of the Vigilance Police on 2012-97. The contents of the FIR regarding allegation against the accused is false. Then, my lords, what he says, preparation report identified and is marked Exhibit 2 and signature of witness in the last page is Exhibit 2/1. I signed the report knowing the contents of the report and the content is correct. My lords, in the preparation report, he has submitted about all this demand part. Accepting it, he has signed. Then your lordship may kindly come to page.
And the contents is correct.
Contents are correct, my lords, he says. Even he gives a prevaricated statement has been declared hostile. In spite of that, he admits the contents of the preparation report. That is Exhibit 2. Then your lordship may kindly come to page 35.
Yes.
Para 4, my lords. They have repeated para 3 twice, but it will be para 4. Page 35, the last para, my lords.
Yes.
It is a fact that time of lodging of report and recording of statement of IO, I did not state anything that Moharir Natbar asked me to pay money for my work in the Tehsil office. Now here he gives a contradictory statement, man. he himself says that I did not state anything that Mohri Nakbar asked me to pay the money for my work in the Tehsil office.
Yes.
Then your lordship may kindly come to the evidence of PW2 at page 40. Page 40, the second parameters from the contents. Lordship have it, Mads?
Yes.
Page 40, para 2.
From the content.
Yes, madams. From the contents of preparation report that the complainant had a mutation case. In connection of this, the accused demanded rupees 500 from the complainant. This finds corroboration with the matters what I have pointed out right now by PW1, saying that in the preparation report he has accepted under Exhibit 2 that there was a demand. Now, my lords, may kindly come to the deposition of PW3, who happens to be the overhearing witness.
Yes.
Page 43. The middle portion, my lords.
Yes.
The sentence beginning with, the signature is marked Exhibit 2/3. Middle portion of page 43.
Signature marked
Is marked Exhibit 2/3.
After reaching the
yes, ma'am. That after reaching
The first line also.
complainant.
That after reaching the Tehsil office, I along with complainant went inside the office and found the accused by staying at a distance of 12 cubics. That by, this is important, that by seeing the complainant, the accused inquired whether he had brought the money. The complainant answered affirmatively and gave the money, which was accepted by the accused, and he kept the same in his left side pocket. This is the demand part, my lords. Then, my lords, may come to the PW4. The deposition of PW4, the Tehsildar, my lords. What he says? He says the entire procedure, how the mutation case is being carried out in their office. Page 46, if your lordship may kindly see.
Yes.
The second line. At place of detection. At place of detection, the relevant mutation case records were seized by the vigilance officer on production by the accused. From that record, I came to know the complainant purchased a land by virtue of a registered sale deed, and he applied for mutation in April 97. And these dates are very important.
Yes.
Thereafter, notice was served on party and the case was disposed of by me on 22/8/97. After disposal, 45 days time was given to other side for preferring appeal. Thereafter, the record goes to record room in case of no appeal for issue of patta. By the time of trap in December 97, my lords, these 45 days period have expired by then. Still, my lords, he was having the consent.
No patta was issued.
No patta was issued, and he was having that file under his, my lords, possession. No appeal was issued. No appeal for issue of patta. By the time of trap in 97, no patta was issued to the complainant. After time limit, the case record was not sent to the record room by the accused. Well, this is deliberately done so as to take the bribe from the requirements. Then
he says that since the informant himself is not paid that amount, that is why it is not moving.
Well, paid that amount, no suggestion was put, my lords. No suggestion was put to that effect. Then your lordship may kindly come to PW5, my lords. He was a member of the raiding party, page 47.
Yes.
Page 47. My lords, the sentence beginning with the complainant was introduced.
Yes.
Lordship, have it, my lords?
Yes, yes.
The complainant was introduced to all present there by inspector. The complainant explained his complaint that he had some mutation problem, and accused mutation clerk demanded rupees 500 from the complainant. By saying so, the complainant produced 500 in cash. This is with regard to the factum of demand, methods. And my lords, the same page, last but the fifth line, methods. The numbers of currency notes. Lordship, have it, methods?
Yes.
At the bottom, methods. The numbers of the currency notes were kept in a white folded paper, and it was given to complainant with instruction to give the notes to the accused on his demand.
One witness, Ajit Mahanti, was instructed to go along with.
He was the overhearing witness, my lords. Well, that is not important, my lords.
The factum of
Demand is very well proven. Very well proven vis-a-vis the preparation report, where he says that the contents of the preparation reports were read over and if I found it correct and I have put my signature. Acceptance is always there, my lords. Then your lordship may kindly come to the page 51, my lords, the IO, statement of IO.
IO. Yes.
50, it starts from page 51 or 56.
PW6.
Page 51, PW6. Lordship may kindly go to page 56 also.
Yes.
No, this is the examination of chief malice. Read page 56, your lordship. Got it, matters? Para 9 minutes.
Yes.
Page 56.
PW1 had presented.
PW1 had presented a written report before me at Vigilance Court Office, Kendrapada. At that time, PW1 came alone. On the date of preparation on 2012-97, PW1 came alone and was present. I had examined PW2 on 2012. PW2 happens to be the magisterial witness. And on 30-12-97, PW2 had stated before me that PW1 told that the accused demanded ₹100. This further establishes the factum of demand. Then PW3 has stated, para 11, PW3 has stated before me that at the place of preparation, PW1 was introduced to them, that PW1 told that the accused demanded ₹500 from him as bribe concerning his mutation case, that he was chosen as overhearing witness to overhear the conversation between PW1 and accused and to see the transaction between them. Then the rest things are not that important. And my lord, so specifically was taken that had the bribe money would not have been given, then it would have been dismissed and sent to Lok Adalat. That Lok Adalat notice has also been seized.
No,
That
why
thread,
the
that
matter
thread
that,
that
see,
thread that
if it is disposed of, it may not be sent to the Lok Adalat. Why Lok Adalat?
And this is what he has threatened the decoy at that time, that if you don't pay me the bribe, then I will dismiss and send it to Lok Adalat. So in order to prove that factor, my lords, Exhibit 10 is there, which is a Lok Adalat notice also.
Lok Adalat notice is manufactured.
No, my lord, it is there. My lord. It is seized. We have seized it. It's there.
What is the relevancy of that?
Relevancy, my lords, I want to impress your lordship that the accused has said that if you don't give me the bribe money, I will disperse it and I will send it for the Lok Adalat. So he was in all readiness. In the event the bribe is not paid, he will dismiss the petition and have sent for Lok Adalat.
How can he dismiss? Already Tasildar comes and says that it is allowed.
This is what the impression he has given to the accused in order to take the bribe from the complainant.
But Lok Adalat notice, how it has come?
It has been seized, my lords. You may see Exhibit 10. It's there.
You got it exhibited through whom? Exhibit 10.
Lord,
what have you asked?
This has been proved by the IO perhaps. Series. And was that apart, the mutation case record was also
why
used.
this creates a doubt?
Yeah. And the mutation
see, whether it was disposed of or not, that is again a doubtful thing.
Right.
If it was to be sent to the local Adalat, then the Tasildar's statement that I have already disposed of the matter creates a doubt. Then the matter was never disposed of. For correction of ROR, for mutation to carry out, where is the question of sending it to Lokadar? Mutation case was disposed of accordingly. That
No,
is maybe
it was not
that was disposed of on 22/8/2097.
It was not finalized, in my humble submission. It was still pending.
Then Tasildar is telling lies.
My lords, he says.
It is your witness.
My lords, he has said that it is not. He doesn't say
Disposed
that.
of. He says very specifically disposed of.
And thereafter, it has to be sent to the record room, my lords. After
For
disposal.
record room, where is the question of Loka Adalat?
My lords.
And you bring that document on record, Loka Adalat notice, to prove what? This creates a suspicion. How the trial court deals with that?
That's what I was searching for.
Verify that part.
Yes, I will verify.
Put it next to
My lord, may see paragraph 13 of the impugn judgment.
Let him verify that. That's very substantial.
Paragraph 13. PW1 in his own hand wrote of the FIR that accused was demanding 500 from him, lost that on 19/12/97. On the next day, he went to Vigilance office and requested.
What do you want to say here?
Well, that local portion was never dead. And he has also, the trial court come to a finding that the mutation case of PW1 was disposed of on 22/8/97, and after 45 days, it is to be sent to the record room by the accused, which he did not, which is evident from the evidence of PW4, the Tahsildar. He also made endeavor to come to the rescue of the accused, that due to pressure of work and sort of, the accused could not have sent the record room. But not,
If the matter was disposed of, whereas the question of sending it to Loka Adalat, that is what I am asking.
the first story, your lordship will kindly see at page 26. The wording Loka Adalat is there.
Exhibit 10 is the notice.
Yes, I'll also place that portion of his evidence which my brother relied upon. Your lordship may see, Sri Mollababu କହିଥିଲେ ଯେ ତୁମର ଦୁଇଟି କେସ୍ ଫଇସଲା ହେଇ ଯାଇଛି, ଏହି କେସଟି ପାଇଁ ଅନ୍ୟ 1000 ଟଙ୍କା ନଦେଲେ ମୁଁ କରିପାରିବି ନାହିଁ, ଯଦି ଟଙ୍କା ନ ଦିଅ ତାହେଲେ ଏହି କେସ୍ ଲୋକ ଅଦାଲତରେ କେନ୍ଦ୍ରାପଡ଼ାକୁ ପଠାଇ ଖାରଜ କରିଦେବି। ଆଜ୍ଞା କେସ୍ ତ ଯଦି ସରିଗଲାଣି ତାହେଲେ ଲୋକ ଅଦାଲତକୁ ପଠେଇବି କଣ?
That part you have to clarify. Just check it out.
ପଠେଇବି କଣ ଆଜ୍ଞା? ଆଉ ଟିକେ ସାର୍ ଗୋଟେ ମିନିଟ୍ ଆପଣ ଯଦି ଦେଖନ୍ତି ସେ ଯୋଉ ଏକ୍ସିବିଟ୍ 10 ଟା ଯୋଉଟା କି ସେମାନେ ହାର୍ଡ କରୁଛନ୍ତି, in the cross examination at page 57. As I have seized exhibit 13, I did not make any further inquiry. Exhibit 10 has been issued from the Tahsil office. I did not inquire whether a local court was scheduled to be held on 21/12/97.
So that part is very dicey. We have to ascertain what exactly has happened, whether if it was disposed of, it was supposed to be sent to Lok Adalat.
And their witness says it is disposed of. Exhibit 13 says
So
it is
the
disposed of.
Tahsildar himself came to the witness box. He says that I have disposed of.
I have disposed of the case. What more remains to be decided?
My lords, I think again that same thing is being canvassed, that there was no work pending, so there was no acquisition of pay.
Then you read that portion.
7(1)(d). And
But
then
while
that part,
I just want to
20
see, he is creating a doubt on the demand part. He says that since there was nothing pending, nothing to be done, where is the occasion of demanding? So therefore, he buttresses his defense, saying that this money was written by that not towards that rice.
Purchase of rice. And you know what?
In the other case which Mr. Nayak was arguing, there he had no defense.
Yes.
Therefore, you are bringing 20.
Yes.
But for him, 20 he tried to discharge his honors.
So that is the reason I'm not buttressing 20 minutes. I'm
So therefore,
7(1)(d).
You look into it. 7(1)(d) is
Seven
all
is
right.
there.
All right.
And-
Even if it's not there.
Yes, and recently Supreme Court in Sita Soren case, your lordship knows, has clarified everything as far as Section 7 is concerned.
Next week देख के रखना, ठीक है? Yes.
Next Monday. Lordship may treat it as hard in part, so it will come in the up. I can go.
In part only. Notes, everything I have.
Notes I have given.
But I marked it out. So easy.
Notes are given, I have given copy to my learned friend.
Yes. Also
162.
162, there are 3 appeals. I am appearing in
162.
Criminal Appeal 308 of 2011. The other 2 appeals are by the contractor and by the managing director of the corporation. 162.
This will take some time, Alex.
It will take some time, no doubt.
That's why I call this and fix a date because it's a misappropriation matter. It will take some time.
Basically, my lords, there is no case against me. And I have been implicated on the basis of suspicion. 120B is a convenient cover wherein one can be implicated even without any materials. And that is exactly what has happened. There is no mens rea against this.
What is, I make a minute, you don't.
Yes.
Give a overall idea, what is it?
Briefly, my lords.
How much time it will take?
No, it will
Because
take some.
When Mr. Panda is there, he complicated case also he makes.
No, because I will only submit so far as my appellant is concerned.
Yes.
But since there are 2 other appellants.
You are for Praful Chandra Das.
No, I am for Arun Charan Parida.
Senior project manager of Odisha.
Let us understand what exactly the case.
The basic allegation in the FIR, my lords, is this. Would your lordship see the FIR? FIR is at page 69 of the paper book.
Yes.
It reads like this. Information received from source is that in furtherance of a criminal conspiracy, Sri Arun Chandra Charan Parida, it will be, and SKB Narayan, while functioning as project manager and managing director of Orissa Bridge and Construction Corporation Limited, here after referred to as OB&CC Limited, respectively by abusing their official capacity, showed undue official favor to Sri Prafula Chandra Das of Messrs. Eastern India Construction Private Limited, Cuttack, by awarding construction work of high-level bridge over river Bhargavi at village Swando on Patnaikia Bellapur Road in Puri district, thereby causing huge loss to OB&CC Limited, in which Sri P.C. Das and others were consequential wrongful gainers of more than lakhs of rupees. Now, in respect of this paragraph, my lords, my appellant, my lords, he was in the corporation from June 1995 till he retired in September 1997. And the other co-accused, SKB Narayan, he joined my lords the day after I retired, my lords. So there could have been no conspiracy between him and me.
No, after you retire, he came.
Then they say,
meeting of mind preceding the crime. Principle.
Then they say it is alleged that Sri Arun Parida, while functioning as senior project manager of the corporation, without going for open tender, violated OPWD rules and Odisha government financial rules and issued quotation call notice dated 30/12/1995.
You are for only 120B.
Yes.
Only 120.
No, since I was a government servant, all other offences are
But
there.
primarily 120B.
Primarily, the allegation is under 120. This, my lords, bridge was to link the birthplace of Utkalamani with the main road, my lords. The minister pressed hard. I was not a member of the tender committee. In fact, that evidence is there on record that I have not assigned the tender. But allegation is that because I was an executive engineer, P.C. Das had executed some contract works with me when I was posted in Jagatsinghpur. So therefore, the prosecution says that because I had a nexus with Das, I brought him in here and got him the contract. The second part of the allegations is
he was not, this contractor Das was not operating in this area.
He was operating here, there and everywhere. He is a licensed contractor. But what they want to bring in is that he was doing contractory works in Jagatsinghpur. I was posted there for some time. So I knew him.
You worked there also.
And therefore
When
I
you
called
came
him.
again, you brought him and
Yes.
got the work done.
Though I was in no way associated with the tender process. That evidence is there also. The other aspect.
You were in an influential position to influence the tender?
I had no position at all. The tender committee was different. It has been accepted by a tender committee.
Tender committee headed by
Headed by other officials.
Engineer senior or they are junior?
Seniors.
Senior. Engineer in chief.
Then you are not in a position to influence the seniors. That's the whole gamut of it. Sir, are you ready in this matter?
Yes.
But he wants let it retain in the board. Prepare it and I'll take it up.
22nd, Your Lordship. I was just requesting my senior to take it on 22nd. He said, okay, it's 22nd will be fine.
22nd of
August month.
Or let it be there.
Yes.
Whenever you are ready, I will take it up.
Yes.
Don't adjourn it. Let it be there on the board.
Yes.
And what we'll do is, whenever in between, if you get the time, this week or next week, I'll hear them and thereafter you answer.
Yes, partner, Your Lordship, and keep it and I will answer them.
Answer.
Yes.
A written note you have ready?
Yes.
We'll prepare.
Prepare a written note, give, and pagination and all, everything. So that we'll hear, I'll
Yes.
hear you and he will answer.
Right.
That will be easier way to
Yes.
Let it be there. If you are ready tomorrow, day after, any time you mention,
we can start.
I'll take it up. No problem. At 3 o'clock.
Okay.
Okay. Yes. Any more matter? Any matter? Yes, sir.
Matter at 54 serial number.
Yes. Yes.
Your Lordship may take it up any other day, but may I file the notes of submission today also? Because it's a trap.
Yes.
Trap case.
Let it be there. You prepare.
I have already prepared, my lord.
Let this be there. Get ready and come. Give a note. I'll take it up.
Should I file the note today, my lord?
No. When you argue, you give a copy first.
Yes, my lord.
Give a copy to him.
Yes.
Which matter is this?
Item 54, my lord.
54. Give a note. Yes.
Serial number 54.
54. Let him look at the file.
My lord.
And I'll take it up. Yes. When you argue, give a copy to me so that let him get the file with him. Yes. Any matter, any more matter? And I told someone to get the photocopy and give. He got the photocopy. In one matter, which matter was that? Huh? No. Somebody asked for a passover. I told him to get a photocopy and come.
Yes, my lords, that matter.
Where is it?
Yes, vanished.
He went to get the photocopy. I said, get the photocopy and come. Which matter was that? It is there. It is there. I am not adjourning. Which matter was that where I said get the photocopy? Some 60. This list will remain. No?
Yes.
Tomorrow he'll come. Photocopy.
Yes.
Okay.